That's okay. We're paid hourly. You guys have Wi-Fi in here? Nice.
Good morning, everybody. Welcome to the meeting of the California Fair Political Practices Commission. I hope you all noticed there are donuts and banana bread out in the lobby. This is a kindler, gentler meeting today, so we welcome you to partake of the food, and you can certainly get up and go get food and come back. So, and I believe, is it legal to eat in this room?
Sure. Today it is.
Today it is. All right, so please do, everyone. Given the length of the meeting today, I won't give a full chair report, but I'll mention a couple of things at the end of the meeting. But I did want to mention for everybody that our October regularly scheduled meeting will be canceled, and the next meeting is November 14th at 10 a.m. Would you like to call the roll?
Commissioner Kasher,
Here.
Commissioner Eskovitz,
Here.
Commissioner Wasserman,
Here.
Commissioner Wynn,
Here.
Chair Ravel.
Here. Thank you, and welcome to all the commissioners. Full commission with everybody present in the room. The next item is for public comment, and this is for anybody who's present here today who would like to comment on an item that is not on the agenda. Sir.
Yes, thank you very much. This is the kinder, gentler meeting. Apparently you didn't see me sitting here.
I missed what you just said.
Apparently you didn't see me sitting here. You may remember me. I appeared before you at the August 22nd meeting. Your secretary was very courteous to me. It turned out that it was very first day and she had no idea what she was doing. Someone else had to step in and squash me like a bug. During that presentation, I said, you develop a collegial and familiar relationship with the criminals because you see them every day, and the honest citizens you see once every 20 years, and they are like dirt under your fingernails. Now, a conscientious and courteous, astute commissioner would have said, gee, what happened to you 20 years ago? I'm going to tell you anyway. In San Francisco, we had a $100 million
Sir, would you mind, for the record, giving your name?
Sure, James Chafee.
Thank you.
From San Francisco. We had a $100 million project in San Francisco to build a new main library. In 1992, we had a library commissioner who had been there for 2 years without filing any statements of economic interest whatsoever. I filed a complaint with the FPPC. That commissioner had been on the Arts Commission before that for 12 years, most of it as president. She had also been running a consulting firm to advise artists on public contracts and that sort of thing. She had also never issued a statement of economic interest to those 12 years either. I wish I could tell you that there was some artist who committed suicide because his career was destroyed because he was not part of her nefarious network. I can't do that, unfortunately. I can tell you that there were whole programs that were collapsed because they were turned over to corporate sponsorship, and people didn't want to volunteer to promote American Express or Bank of America Visa, and that the entire art culture in San Francisco was skewed by this unreported network that almost everyone except me was afraid to report on. Of course, what the FPP said was that this was excusable because this lady was, quote, new to public service. Well, of course, the FPPC investigator did not contact me. It would probably be a waste of time for him to confirm that I am not on board with the idea that a 14-year veteran is excusable for being new to public service, especially when she's distorting the whole idea behind private interests being run from her public position. This is tantamount to you throwing trash out of your car driving down a mountain road. And of course it picks up snow, and at the bottom of the hill, whole communities are wiped out. You know, for what you...
Sir, you have 30 seconds.
Well, thank you very much. The point is that this costs the society social capital, and it's not yours to spend. You know, we've built up trust in the community based on the idea that people have an investment in the community, and as I say, it's not yours to spend. I guarantee you that Marie Antoinette did not have the contempt for a footman that a government employee has for me, and this turns back hundreds of years of progress. Thank you very much.
Thank you very much. Thank you for your comments. Yes, sir.
Good afternoon. I'm Peter Warfield, Executive Director of Library Users Association. I live in San Francisco. My first question is with respect to procedures. You've got a consent calendar for items 2 to 22, and I wanted to know if the item concerning San Francisco City Librarian Luis Herrera, number 22, will have public comment or will be pulled from the consent calendar.
If you are interested in making comments, sir, we will pull the item from consent.
Thank you. In that case, I'd like to address myself to some fairly troubling learning that I've done since the last time I was present at your last meeting. The enforcement proceedings that you have are not, in my view, very helpful or fair to the public. What was apparently difficult to find, but eventually somebody found your enforcement proceedings, you've got what seems like an exemplary administrative hearing procedure, which has some of the elements that one would expect from an adjudication that's fair, just, and, if you like, constitutional, or at least as outlined in the Constitution. It's public, which stipulations are not, and it considers appropriately the seriousness of the violation, the presence or absence of any intention to conceal, deceive, or mislead, whether the violation was deliberate, negligent, or inadvertent, whether the violator demonstrated good faith, whether the violation was isolated or part of a pattern, and whether the violator has a prior record of violations. The stipulation procedure looks as though it's entirely driven by staff without even input from the complainant or members of the public. Presumably, in setting a fine or a consequence of a violation, you would have to find out all these things that are involved in an administrative hearing to appropriately deal with the issue. But the stipulation looks as though it completely occurs in the darkness, if you like, of the staff, and that the only thing you get here is the final stipulation, with an opportunity simply to vote yes or no on that stipulation. it says in voting on a stipulation, the Commission is limited to adopting the stipulation and fine amount in its entirety or rejecting it in its entirety. Since the stipulation and fine amount have been agreed by both parties, not clear which two parties are involved. Is that the staff here and the lawbreaker, if you like, or is that the complainant? And where is the complainant in this? Anyway, it goes on to say the Commission cannot increase or decrease the amount of the fine. Any change to the stipulation would have to be fully negotiated and another stipulation presented to the Commission. I hope this is on your website, and I hope that I have what's current with regard to your enforcement proceedings.
You have 30 seconds, sir.
Thank you. It's very troubling that stipulations seem to be handled, as I said, in darkness from the public, not in public. The public has apparently no opportunity to know what passed between the staff and the respondent, what claims were made falsely, incorrectly, mistakenly, or any other way. And it seems like a very troubling procedure that completely lacks what we would normally expect from an adjudicatory process. Thank you.
Thank you. I think that your comments merit some, at least, response or statement by the Chief of Enforcement. Mr. Winnick.
Thank you, Madam Chair and members. Gary Winnick, Chief of the Enforcement Division. I guess I can just simply say that we do receive over 1,500 complaints a year. We open 1,000 cases. I think like any other law enforcement or administrative regulatory agency, you know, we follow the guidance of our commission in terms of what procedures to follow. We follow appropriate law and regulation as to how to conduct investigations. But I think we can all understand, hopefully, that conducting investigations in public, I don't think serves either the investigator or the accused very well. Our staff is professional. We have lawyers, we have trained investigators, we have our own internal and external ethical standards in how we conduct investigations. And I think we have a real 35-year track record of finding facts and applying the law as it's developed to those facts. Ultimately, that comes to you in several different forms. The most common of which is a stipulation. For minor violations, the direction has been to have a streamlined process, to have an appropriate penalty level for the culpability, but for more serious violations to articulate what the actual violation was, what the penalty is, how that compares to past penalties. I actually think in terms of that process, we put more in our agreed upon stipulations than many other agencies and enforcement agencies do. We don't have the equivalent of a no-low contendere plea where you just sort of no contest the violation. We actually make people agree that they articulate to it or that they committed that act and that they agree that the statements of facts in it are true. All that, by the way, is supported by evidence that, unlike many other agencies, becomes a public record after that's been adjudicated by yourselves with a final determination. And believe me, we spend, my legal staff will tell you, we spend a lot of time putting out a lot of that information. So we, I think, operate under a higher degree of scrutiny maybe than any other agency I'm aware of. But again, I think there are very legitimate purposes why the public and the complainant can't participate in the investigation. It obviously compromises information. It can unfairly paint someone who may not have committed a violation with additional. It could play out our investigations in the media, which we've tried carefully during the investigative phase not to do, especially given the type of parties that are involved in our cases. So I think, you know, overall there are a lot of solid reasons in history behind why we do what we do, and I can go into more detail if you like.
Yeah, Commissioner Wynn.
Thanks very much, Gary, for that explanation. So I'm assuming that Mr. Herrera is going to file these three.
They've already been filed.
They've already been filed.
It's
So
a
I mean, I
condition
think
of
that
settlement
is
for all
the
respondents.
public. You know, the public then gets to see the information on what this.
Correct.
So.
For all of our stipulations, it's a condition of settlement that the parties file the missing statements, if you will.
Okay. Thank you very much, Mr. Winnick. And as you know, sir, this is public comment, and therefore there is no action that can be taken by the Commission with respect to your comments at this time. The next item is the proposed consent items, calendar
Your
items.
Honor, Sorry, I keep calling you
Oh,
Your
I'm
Honor.
so sorry.
I'm tr-
Just keep calling me Your Honor.
you know,
It works for me.
forgive a commissioner from going slightly off topic, but I have a very close family friend who has asked me to make this sort of statement whenever I can when there are people about, and it is not reference to any candidates or ballots or things like that. But I'm sure Zach will shut off my mic if I go off. Anyway, I'm family friends with the family of Kenneth Bay. He went to high school with me in Torrance. He was class of '88. I was class of '91. He was convicted in North Korea of activities involving his faith that were considered to be anti-regime, and he's been in a labor camp for over 325 days, and he's not doing well. So the family has asked me at any opportunity to put his plight out there in front of anyone who may be interested, because we want him to come home. Thanks.
Thank you, Commissioner Wasserman. With regard to proposed consent calendar items 2 through 22, perhaps we could just take the first one, the approval of the meeting minutes separately. Is there any question or concern, or can this be voted on by consent? Okay. So maybe what we should do is, since I just took it off, vote on that item. Thank you.
Commissioner
Yes,
Kasher?
excuse me, sir. Sir, minutes are solely within the purview of the commission to vote on. So you want to make a comment about the minutes? Feel free. Come forward. But
I'm Peter Warfield again, Executive Director of Library Users Association. Last time I did comment on the minutes and commented that they were not very informative with respect to public comment. And in a sense that disenfranchises the public as well. These minutes, as far as I have seen them, basically list the names, but essentially only in the vaguest terms the topics that the folks have talked about, without indicating what their position was, without indicating what the specific issue was. And I think that it really would serve you and the public much better if you would indicate with a little more information what specifically the concern was and what specifically members of the public had to say. After all, members of the public aren't commenting that frequently here. They come at considerable time and expense to themselves, and presumably consider the matters important enough to make the trip and to speak to you. And so I would express opposition to the approval as they stand now, because the members of the public are simply not represented as to what they have to say, and in particular what those of us who came from San Francisco had to say with respect to the library matter that was then pending. Thank you.
thank you, sir. Is there a motion?
I move to approve the minutes of the August meeting as presented.
Second.
Commissioner Kasher?
Yes.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
What was there? Were you trying to speak on this issue?
Yeah,
or-
he made
Oh.
public comment. I wanted to make public comment.
Oh, I'm sorry.
All I have to say is that
Sorry, Madam Chair.
I'm
I was
sorry,
just
I
looking up
didn't
and I
s-
said,
I didn't see you stand up, sir. I know. I didn't see you at the beginning either, or I would have changed the whole format of the meeting. Sorry. Please accept my apologies.
thank you very much. All I can say is that it's both an action item and it's your historical record. And if you don't want to hear the public comment, before you approve that, it speaks very ill of your knowledge of open government laws.
Yes.
so there, in my experience, there's always sort of the danger of too little, which is not useful, or too much, attempting to have a transcript, which is going to inevitably create inaccuracies, etc. I would like to see maybe a little bit more, because I note my own memory, I can't even suggest additions to the areas where it says Commissioner Wasserman requested and received clarification on the matter, because I received a clarification. It must have been fine, but I don't recall exactly what it was sitting here. So maybe some sort of middle ground.
Let me just say the full record of the commission meeting is online. There's ample ability for the public to get information about what transpires in these meetings, and the staff, Ms. Breton, has a full-time job doing a lot of other things, and so reflecting the minutes of the meeting is required and positive to alert people to what has been transpiring at the meetings, but they can always go to the record to get the full information.
And I think what you've just mentioned is probably a great thing for us to just remind people now and then, because I think that serves the purpose perfectly. Thank you.
Thank you.
Commissioner Wynn?
Aye.
Commissioner Wasserman? I don't think.
Aye.
And Chair Ravel?
Yes. Thank you. And now to the enforcement matters. I know there are some items that people will want to remove from the consent, including item number 22 that has already been requested to be removed. Are there any others by the commissioners?
Yes, Commissioner Eskovitz, out of an abundance of caution, I'm going to recuse myself from consideration of numbers 10 and 16 and ask that they be removed from the consent calendar.
Okay. Are there any others?
Pardon me, I have a question. Zach Morzani, General Counsel. Commissioner Eskovitz, are you just abstaining or recusing yourself from those?
No, I'm asking right now that they be removed from the consent calendar, okay. And then I plan to recuse myself and not vote or participate in consideration. Right.
Okay.
Recuse myself, not just abstain, but so not participate in deliberations either.
Thank you. Hearing none other, I want to not remove, but just make a comment about item number 3. Is there anybody else in the audience that is here for an item that they would like to comment on that is on the consent calendar? What number? I'm sorry. 3. Item number 3. Oh, okay. Item. No, I appreciate that. I'll remove that. Is there anybody else? Okay, so with respect to the remaining items, and that would be 4 through 21 with number 10 and number 16 also removed, is there a vote? Or a motion, excuse me.
I move to approve the consent calendar from items 4 through 21 with the removal of 10 and 16.
I'll second.
Okay.
Commissioner Kasher?
Yes.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Ravel?
Yes, thank you. Okay, item number 3, sir.
Good morning, Commission. My name is Daniel Pillay. I'm with Consumer Watchdog. And firstly, we would definitely like to commend the Commission for bringing to light the trade of so-called shadow lobbyists and levying fines against California Strategies. Secondly, we would respectfully ask that the Commission postpone the approval of the stipulation prepared by your staff in the case of California Strategies, and more specifically Winston Hickox, for further review. We are particularly concerned by the failure by Mr. Hickox and California Strategies to disclose apparent lobbying on behalf of the Boeing Company is not addressed in the decision. We understand that Mr. Hickox, a former secretary of the Cal EPA, has used his influence with Cal EPA and DTSC on behalf of Boeing in an effort to relieve Boeing of its obligations to fully clean up the contaminated Santa Susana field in Simi Valley. which is a nuclear meltdown site near Los Angeles, but has not filed disclosures about this work. As my colleagues and I understand it, this firm and these individuals must now register as lobbyists and disclose all their clients and income for work that was kept secret. As of the end of business yesterday, and I apologize if it's been updated this morning, there was no such public disclosure on the Secretary of State website. We think it is important for the public and the Commission to ascertain whether Mr. Hickox and California Strategies are disclosing the work for Boeing before a decision to approve the settlement agreement is made. If the proposed agreement immunizes Mr. Hickox and California Strategies from investigation regarding potential unreported lobbying for Boeing or other clients for that matter is not identified in it, we think that it should be disclosed to the public and the Commission. We would thus respectfully recommend that the approval of the agreement be deferred until it requires full disclosure of the Boeing work. If the Commission decides not to do this, we think the matter should be held over until there is full disclosure of all items, including any agreement between the Commission staff and Mr. Hickox, immunizing Mr. Hickox and the California Strategies against penalties for undisclosed lobbying for Boeing. The FPPC has done a laudable job to shine an official light on the dirty business of shadow lobbyists. So we urge that you continue to shed light on Mr. Hickox Boeing lobbying and publicly disclose that the FPPC waives its right to investigate the matter within the agreement itself. Thank you.
Thank you for your comments. Mr. Winnick, would you like to respond, please?
Sure. Gary Wenk again, Chief of Enforcement. We appreciate the comment. The statements that are being described, the lobbying disclosure statements, were filed with the Secretary of State yesterday. I think there's a lag between the public posting of those and the paper filing of those. I'm not sure, honestly, what the lag is. They may be available today. I'm honestly not positive. With regard to the Boeing issue specifically, we did, in the course of looking at this matter and negotiating the settlement, review some evidence and information related to that item specifically. In our estimation, from what we were able to determine, there was not lobbying happening on that specific issue. All the lobbying that we uncovered, if you will, as a result of this was in fact disclosed and is subject to the stipulation. You should know that the stipulation does contain language that this does encompass a complete resolution of their lobbying for the period. So in that sense, he's correct. But the issue he's describing specifically was looked at.
Are there any questions? Commissioner Wasserman.
Thank you. So, Mr. Winnick, just to make it clearer for me, the respondents submit their reports. If those reports themselves omit something, or for whatever reason, negligent, inadvertent, etc., they are still open to possibility of some sort of action if those reports are incorrect. Is that correct, or is this all saying they've been previewed and we're good with that?
We preview the reports before they're filed. Generally, virtually all respondents will send us a copy ahead of time to make sure it meets our requirements under the stipulation. That was done in this case, and then they were filed. Pardon me. But to answer your question directly, if there are errors in the filings that are related specifically to the items in the stipulation, those would need to be corrected. But we have reviewed their activity over that period, so if there are additional instances of lobbying, they would not be subject to future enforcement action for that time period.
Now, if however, additional facts and evidence come to light that would have changed your mind about those being acceptable, are they still, quote, I don't like using the phrase immunized, but that's what's been said.
In the stipulation, we've called it a resolution of all matters. So okay. I think there's a limitation to that if there's campaign money laundering or something that's outside of the conduct described here. But other than that, it's a resolution of these issues.
A general release, correct, essentially, within the subject matter. All right, thank you.
Commissioner Wynn.
Thank you very much, Gary. Is that fairly typical, that you would resolve all matters within the stipulation?
It is. It's I won't say it's every single case, but it's virtually every case, particularly ones where there's a volume of matters. Generally, when we're entering into a stipulation, I think it would be unfair of the Enforcement Division to reach a stipulation and then go back and prosecute again on the same thing. So it's pretty common for people to ask for a joint resolution. We take that into account when ascribing the penalty and deciding what to present to you as part of that stipulation. But I think you can understand why people would want at least that matter resolved as part of the action.
Thank you.
Just curious, is the language that's contained in the stipulation decision in order that's in the binder that we have before us, is that the entirety of the language that you have resolving all matters?
Correct.
And is there some other way that you have discussed what that means in terms of what's encompassed in it?
Yes, we did have oral conversations with the respondents in this case, talking specifically about the issue Commissioner Wasserman raised about the scope of what that means, and I believe we have a common understanding of that.
I know are there any other questions by the Commission? Any other comments in the public? I wanted to speak to just the work that the Enforcement Division did on this matter. As has been already said publicly, this is the first time that the Commission has ever dealt with an issue like this of shadow lobbying, and it was what we call proactive investigation that was done at the instigation of the Commission itself, of the Enforcement Division, and it's something that is very significant. It is part of our emphasis now on looking at more significant matters that impact the public trust, and this is exactly that kind of a case. So I applaud all of the members of the Enforcement Division who've worked on this. Thank you.
Thank you.
So is there a motion?
I move approval of staff's recommendation.
Second that.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Again, I think out of an abundance of caution, I better abstain from voting on this.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel,
Yes. Okay. The next item is item 16. 10. This is in the matter of a committee in support of Proposition 34, sponsored by ACLU of Northern California, and Commissioner Eskovitz has not participated and will not participate in the vote or discussion of this matter. Is there a question by any member of the Commission? Anybody else that has a question or issue? Is there a motion?
I move approval of item number 10.
Second.
Commissioner Kasher,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel,
Yes. Likewise, item 16, which is in the matter of Skechers USA, Commissioner Eskovitz has recused from this matter and is not participating in any discussion or vote. Is there a question or comment by any commissioner on this matter?
I think I'm
Mr.
going
Wasserman.
to abstain. Just simply, it's a very small thing, but I'm involved in fundraising for schools, and Skechers does some things there. And I have a T-shirt, which my son has, a matching T-shirt. I don't think I want to be seen wearing that T-shirt after even being involved in this at all. So I'm just going to abstain.
No shoes, no Skechers shoes.
Not in my office.
Is there a motion?
I'll move approval of item number 16.
Second.
Commissioner Kasher,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel,
Yes. Thank you. And the next item is item number 22 in the matter of Luis Herrera. Yes. Let me first see if there's a member of the commission that has a question for staff on this item. Okay. Yes, sir.
Yes, thank you very much. The good news is that this is even more ridiculous than claiming that a 14-year veteran is new to public service. The bad news is that it's not quite as immediately obvious. First of all, you have your own regulations for the FPPC. Regulation number 18360 says, and I quote, "The Commission investigates the allegations of a sworn complaint. The Executive Director shall notify the complainant in writing of the following: the time, date, location of any public hearing or public meeting on the complaint scheduled to be heard by an administrative law judge or the Commission. I'm the complainant and received no such notice." If you look at the stipulation itself, it says the complainant, the Fair Political Practices Commission, and the respondent hereby agree that this stipulation will be blank as a final disposition of the reported violations. Not only was I not notified before this was put on the agenda, I was not notified at all, even up to the time of this meeting. Let me tell you, first of all, that a department head in San Francisco has to take what we call locally an open government training. It's 2 hours. 1 hour on public records and open meetings laws, and another hour on gift and conflict of interest regulations. And he has to sign a statement under penalty of perjury that he's attended that each year for the last 8 years. Of course, during those 8 years from 2005 on, he checked the box that said no schedules on, nothing to report on any schedule. Let me tell you now what's at stake. Because the private fundraiser that raises about $5 million a year and gives him $65,000 per year has no agreement with the city, they have an agreement with him called a framework, in which he's required under this framework, which was presented to the public as their opportunity for disclosure, that there would be quarterly reports. He's now admitted that there have been no quarterly reports for the entire 8 years. Now, this is a sort of an extortion, if you think about it. He says, I won't expose how little you're giving if you make sure that I get my $65,000 a year. Now, if you look at what's actually taking place, when they passed the bond issue that this is supposed to support this $5 million, they claimed that they were raising $16 million for the city. In fact, over that 11 years, they raised $53 million. Not only did they only give $3.6 million to the city, but that's 1.5% of the public. If you look at the bond issue and the original promise of $16 million, that was supposed to be 15% of the project. Now they're given 1.5%.
You have 30 seconds, sir.
Thank you very much. The point is that this is the leading edge of a major graft. And of course, he doesn't disclose his payoffs, even though he's said under penalty of perjury that he knows about the requirements, and then to turn around when not even contact the complainant and say that that's $600. What is $600? That's greens fees practically in the face of a major institution of graft. Thank you.
Thank you for your comments. Would you like to, or maybe I'll have you all speak and then you can respond to everything. Please come forward. Thank you.
Peter Warfield again, Executive Director of Library Users Association. Last time I pointed out some of the major fundraising that the Friends gets and the major benefits that the Friends gets from the library, which is for the last 8 years headed by Luis Herrera. To start out with, I'd like to say that certainly we oppose this stipulation being approved, not for a number of reasons. The first one, to repeat what the previous speaker said, there apparently was not even the courtesy or the requirement under your own procedures carried out. And that is that the complainant be made aware that this matter is on today's agenda, and that the complainant be made aware of what the stipulation is. The stipulation itself, I think, is a real disservice to the public for a number of reasons. First of all, on the agenda, there's no documentation indicated to indicate that there is a stipulation or what it's based on. The stipulation itself is a single one-page sheet which speaks in rather vague terms about not reporting, unreported interest, gifts from friends of the San Francisco Public Library. Well, what gifts? What was the nature of the gifts? What was the amount of the gifts? Nothing about that. What about the filing of a corrected report? There's nothing that I see here other than an imposition of a monetary penalty, which at $200 per violation on a perjury count. This is perjury under the law. The city librarian specifically checked a box saying he hadn't gotten gifts. Your total for 3 years of hiding the facts is less than 1 day's pay. Less than 1 day's pay for the city librarian who has solidly six-figure salary. But more important, this completely leaves unclear the question of what the process was, what were the statements or the claims that were made to your staff with respect to what was going on. We know nothing of this at all, and you're saying that it's just great to release it after the approval of this.
You have 30 seconds.
This is a long-term pattern. If you look at your administrative proceedings, do we know, and to what degree do we know, you considered the seriousness, the intention to conceal, the violation was deliberate, negligent, or inadvertent, whether there was good faith demonstrated, and whether it was part of a pattern. It was part of a pattern. The library has for a long time hidden its relationship and the things that go on with it. Here's an example of a quarterly report that has never been on the library's agenda or minutes filed by the DPW.
Thank you. You could submit that if you wish.
Okay, and since 2003, the Friends have been giving supposedly $16 million towards a bond measure, and they report regularly on, well, they don't report regularly, but there's regular mention of their donations and their participation in the bond program that started in 2000. This is not something that was an inadvertence. Thank you.
Is there anybody else that would wish to speak about this item? Mr. Winnick, could you please?
Thank you, Gary Winnick, Chief of Enforcement. I guess first I just comment and say that, you know, the focus of our jurisdiction over the issues that are being brought up is really quite narrow. Our jurisdiction is over the gifts that were provided from the Friends of the Library nonprofit to Luis Herrera directly. Some of the issues about filing court reports and other uses of the funds aren't really in our jurisdiction, so our focus was fairly narrow. And we kind of did with this case what we do with every case, which is gather the facts and then articulate and determine what level of public harm there was, what factors in aggravation, what factors in mitigation. Here there was significant mitigation, we thought, for the unreported gifts, not the least of which was these were gifts from 2 or more years ago. Second, that the gifts were ones that could easily have been reported as to the agency itself, and had the agency had a filing obligation if a couple of other facts had been slightly different. And also that a lot of these funds were also run through the county and not sort of done outside of a governmental process. There was some ability to see that those funds were there and for what purposes they were being used for. So taking all that into account, the level of cooperation of Mr. Herrera and the articulation of the gifts, we felt it was at the streamlined level of culpability rather than the mainline level of culpability. So and that's why we brought that recommendation to you.
Commissioner Kasher.
Was wondering if you had a comment respect to the issue raised around notice to the complainant.
Sorry, thank you very much. The Reg 18360 talks specifically about if you file a sworn complaint. I have to say I honestly do not know if they filed a sworn complaint or whether it was an informal complaint. I will research that issue and find out the facts of what happened. I honestly don't have them off the top of my head.
Is there any possibility that you could ask your staff to look into that and report back to us later in this meeting?
I will attempt to do that, yes.
Thank you. Other questions?
Um,
Commissioner.
Mr. White, can you speak at all to the nature of the gifts and the
Sure.
culpability involved in failing to report them?
The bulk of the gifts were meals, generally of a smaller dollar amount, although in cumulative the total was higher, that were used for library business to meet with other library officials and other people that had business with the library. And there was also some travel-related expenses, again related to his work as the I believe it's library commissioner. If I have his title wrong, forgive me. So that was the nature of the gifts that were received.
Are there any other questions by the commission? Is there anybody else that wants to speak that has not yet spoken to this issue? Okay. Is there a motion?
Before we
Do you wanna
make
wait?
a formal proposal, I guess I'd feel more comfortable if we got an answer on the notice issue,
Okay.
and if there's no hurry, we can deal with other things in the meantime.
Okay. Certainly. Maybe you should show it to Mr. Winnick, and he can make a determination. Thank you.
Well, he has a sworn complaint form. Again, I'd have to check our records and see. I honestly do not know if a notice was sent out.
If there was notice.
I'm not disputing
and
his
the
word on it,
notice
but
that's
I honestly don't know the answer.
and the notice that's required by our regs and by the statute is notice with respect to the instigation of an investigation, correct?
That was provided. He's actually talking about the notice of this
Of this
particular hearing.
hearing.
If there's going to be any public hearing, I believe the actual language, any public hearing scheduled to be heard by the commission. Yeah, that's pretty much the relevant language. So I think it's more leaning towards if there's going to be an administrative hearing, but I think it could be read broadly to do that. Just for a fact, I probably, to the best of my knowledge, we actually do not send those letters out, so it would not surprise me if we didn't. So.
Right, and I think the question for the commission, at least in this instance, is, well, they may have failed to follow the letter of the law. Clearly, a notice was received by these individuals, so I think there has to be some decision with respect to that.
And it did
issue.
receive significant press coverage in the Bay Area as well. But.
Yeah, I mean, obviously the complainant in this case got notice enough to appear, so I'm not particularly concerned about this case. I would, I guess, urge us to take another
Sure.
look at the reg to make
And
sure.
I will go back
procedures
and
are in
review
place.
that and make sure that we'll take a fresh eye at that and report back to you at the next hearing.
Okay. Any other questions or comments? Commissioner Wasserman.
I'm in agreement in as much as the complainant is able to appear and set forth, and make comments. I wasn't prejudiced and not able to, set forth things that he needed to put in front of the commission. So, but I would like to see this dealt with. Thanks.
Any other comments? Is there a motion on this matter?
Move to approve the commission's, the staff's recommendation.
Is there a second?
Second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn, Chair Ravel.
Yes. Okay, thank you. The next item is item number 23, Regulation 18329, definition of lobbyist. Commission Counsel Heather Rowan and Zach Morazzini.
Morning. All right, the first regulation we're looking at is 18239. It's a definition of lobbyist. We're making a small change after
18329?
18239.
Is it 239? My
Let me go to the
agenda
next page.
says
18239.
Okay, the written agenda says something different.
Oh, I see.
So it's okay.
So the definition of lobbyist.
Right.
So the change is fairly simple in response to some new statutes that were passed in 2011 regarding placement agents. Staff has received over the past 2 years several requests for advice, both in writing and over the phone, asking whether a placement agent can bring a knowledgeable person, such as a company's CFO, along to a meeting with a state public retirement board, and whether that person would then qualify as a lobbyist. The proposed change extends the ride-along or accompanying provision that we've long applied to traditional lobbyists to the placement agents, who are now lobbyists under California law. It codifies staff advice by allowing a person to attend a meeting with a public official at that state retirement board, and does not require that that person registers as a lobbyist for attending that meeting, provided that that person is in the company of a registered lobbyist, and does not otherwise meet the definition of a lobbyist. The accompanying persons are generally knowledgeable about the topic at hand and attend the meetings to provide further, often technical information. They are not registered lobbyists and do not become registered lobbyists simply by attending such meetings to provide information. One change that was recommended by a couple of people late yesterday is to add one word on page 1, line 18 of the regulation. The change would delete the word independently and insert the word otherwise. The request was made to clarify that that person who attends the meeting along with the placement agent doesn't become a lobbyist during that meeting, but his or her other activities in the regular course of his or her job could qualify that person, but it's not this meeting that does it. So it's a couple of comments yesterday said that that would be a little bit more clear in terms of applying the regulation. Other than that, it's as submitted, and we welcome your comments on this regulation.
Are there any questions or comments by the commissioners? Commissioner Wasserman.
Yes, thank you. I know sometimes I go through the elementary first and work our way up. With respects to the agenda item itself, Regulation 18329 on the agenda, do we have any issues with having properly noticed this item? It says definition of lobbyist, and the explanation in the agenda item has the correct number. I wanted to get that out of the way first to make sure that we can talk about this. You know, when you have a typo as to what's
Yes, we can talk about this.
Okay. Now, with respect to these, the purpose of what we're doing here is in order to allow technical personnel or something like that to have these discussions without having to be reported. I mean, I guess the summation of why would we need this regulation change?
The purpose is to avoid over reporting of someone who is not whose job it's not to market a state public retirement system. The person who's actually doing the marketing or doing the lobbying is registered as a lobbyist, is reporting the contacts that he or she has. But to bring someone along who has more information and to have them start reporting based on that meeting seems a little excessive, and a lot of the comments we get are along those lines.
So with this change, if, say, a geologist goes to a meeting and receives over $2,000 for their services for this meeting, are they still going to end up being a lobbyist? Not a placement agent. Maybe a geologist isn't the right example, but an individual shows up, receives over $2,000 in order to show up and provide technical information, which is basically meant to support influencing a decision. Are they otherwise covered elsewhere, or are they simply out?
I think that for the purposes of that meeting, they would not become a lobbyist based on their payment. The administrative action in this case is limited to the bills that brought in the placement agent added to the definition of administrative action to be a contract with the state retirement system board, and based on that activity, one becomes a. I'm trying to get around to answering. If this is confusing, let me know. But so the administrative action is trying to get that contract. the person becomes not a lobbyist under the traditional definition of lobbyist, but becomes a placement agent based on that activity. So if the geologist goes to engages in direct communication with a public official outside of this meeting, then this regulation doesn't prevent that person from having to qualify as a lobbyist if he or she otherwise would qualify. But this meeting doesn't do it. And in terms of placement agents, it's they're typically the higher level financial advisors who are attending in the accompanying position.
So to make it kind of more concrete, if you have a placement agent who brings with him or her to a meeting expert in fixed income investments or a particular subspecialty in the field, the placement agent is regulated as a placement agent. This is to prevent somebody with that specialized expertise who's attending the meeting for purposes of explaining prospective investment, let's say in this example, from also having to register as a placement agent, and every time anybody like that attends a meeting, have them also registering as a placement agent.
Right.
Is that the gist of this?
Right.
Any other questions? Is there anyone in the audience that would like to speak to this? Yes, sir.
Well, of course, and I think that my comment is so obvious I almost don't need to say it.
Okay.
Why? Indeed. I apologize for this not being the nice feel-good meeting you were expecting.
I'm just joking, sir.
Why change the regulations if you're not going to have any respect for your own regulations yourselves, and in fact even your own forms? Am I going to be back when I'm 87 to let you shit on me one more time? God, I hope not. I think before then, people are going to cut your throats. You think all you got to do is tell another lie and hire another guard, and people are going to cut your throats. Thank you.
Is there anybody else that would like to comment? Yes.
Good morning, Madam Chair and Commissioners. I actually just have a clarifying question on the
morning.
language. My name is Lacey Keys. I'm an attorney at Holston, Hagel, and Fishburne, and we represent several placement agent clients, and I'm not here on behalf of any of those clients, but just on behalf of...
Excuse me one second.
Sure.
I'm sorry to interrupt you.
But he, like, did he go? Yeah. Sorry,
Want me to
just
come
a
back?
minute. We are discussing security questions. Okay, thank you. Sorry, please come forward again. I'm sorry. That is just a slight hiatus.
That's okay. I think my question's relatively quick.
Okay.
I just wanted to first say I appreciate Heather's willingness to talk to us about the language and make the change to otherwise. I think that was helpful in clarifying when the exception would apply. And I just had one question about the additional substantive information requirement. Heather, again, was very helpful and went through some examples for me over the phone, which would clearly fit and wouldn't. And we talked about someone attending potentially because they have specialty in a field related to the investment. And these meetings kind of have an ebb and flow, and sometimes you don't get to all of the topics that you might otherwise want to cover. And so I just wanted to clarify that someone who attended the meeting for the purpose of providing that additional information, but for whatever reason wasn't able to before it ended, would still qualify for the exception.
Yeah, thanks for bringing this up. We did talk about this yesterday, and I think that the conclusion that we came to was the person who's there to provide information about a particular fund, particular investment, to a particular topic, would be covered under the exception for that purpose. To the extent that the meeting takes a turn, whether it flows there or there's a definite different topic, I don't think that the exception is intended to just cover the entire any topic that comes up. The point being to not force people to over-register, but also not just to bring in a lot of people and say, oh well, he was an expert, and really we don't want to have a lot of lobbyists who are not registering and not reporting, and the public doesn't know what they're doing. They're not subject to the contingency fee ban, which is the purpose of the placement agent bill. So it is limited in that way, and I think that our advice going forward would try to be reasonable in terms of how these meetings go, but also that it's a fairly limited exception.
Thank you.
Thank you. Are there any other questions?
You mentioned that the goal is to avoid the overly burdensome reporting requirement. How has it been working out at this point? I mean, what is the extent of the burden?
What we've heard from particularly folks at CalPERS, and I've spoken with CalSTRS as well, and then people in the regulated community who are representing placement agents, is that when the bill was first passed, a lot of people were registering just out of caution, and PERS and STRS particularly, they're the largest. There are other public retirement systems, but their policies are not to talk to people unless they're registered first. So the Secretary of State's office got a huge rush of registrations in order to, out of caution more than necessity. So what we're trying to do is clarify this and make it so that that those unnecessary registrations aren't going through. It's more of a burden you end up as the lobbyist filing quarterly reports after your initial registration. You have to take the lobbyist ethics training course. So it's those requirements are fine when you're talking about the actual lobbyist, but not necessarily the encyclopedia that the lobbyist brings with them.
As long as they're an encyclopedia, not another lobbyist in another hat.
Exactly.
Because that something I was thinking about was the concern we have in other arenas about folks coming in under one guise and serving in another capacity while they're in the meeting, or...
Yeah, that makes sense. I think that when CalPERS was here for our IP meeting, they kind of explained how the meetings work, and that that the advice letter that we put out, it was the RECT letter 2 years ago, I think, explained that these the people who are going along in the accompanying exception in the lobbying, the traditional lobbying realm, that what CalPERS was explaining at the IP meeting was that it makes sense to have these sorts of exceptions, and CalPERS has its own set of regulations on this. So we also put trust in them to follow both these regulations and their own in terms of who's registering.
But in terms of the substantive effect of this change, this would essentially treat accompanying persons in the placement agent context in a similar fashion to accompanying persons in the lobbying context, right?
Right.
Okay. Is there a motion?
I'll move approval.
Second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel.
Yes. Thank you. Item 24, which is proposed regulation 18421.5, and it relates to committee reporting of payments for online communications. Ms. Rowan.
Okay. So this regulation has been before you the past 2 meetings, and it has been in some form or another been discussed for the last couple of years or more. And we've been working with both individuals and groups to try to figure out the best way to go about this, understanding that it's a fairly new way to look at the way people are gathering their information. We've had a lot of support. There have been a lot of editorials that are in support of this, and Consumer Watchdog submitted a letter, as you may have seen, and CalBuzz, the blog, has been in support throughout the process. We've made a couple of changes since last month, and you'll see those both crossed out and underlined. A couple of points I want to make about those are we have taken out the reference to in-house campaign staff in response to the discussion that we had last month, and added the language favorable or unfavorable to modify content, so it's not just any appearance on any website, but there is some opinion there. And those were the two big ones. The change in subsection D at lines 20 and 21 was just extra words that didn't need to be there. I wanted to talk about one change that that I made before the meeting to try to clarify and to line up B1 with B2, and that is B1 reads providing content for posting, and B2 reads providing content for or posting, and I'd like to insert the word or in one to clarify that. And then just before the meeting, I had a couple of comments to make that favorable or unfavorable more clear in the body of the regulation rather than just in the purpose line. So in subsection B, line 9, I'd like to add, it would read, committee paid to provide favorable or unfavorable content, just to bring that modifier down into the body. And then referring back up to that particular favorable or unfavorable, it would read 1, 2, and 3 would read providing such content, so that you're bringing it back to that modifier. Okay, so I wanted to respond to the comment letter that we got from Mr. Maviglio. I don't want to go through every catastrophic point that he raises. I don't think that we write regulations to consider every possibility that could happen. I think that we write regulations for guidance, and the FPPC works very hard to be available to people to provide advice, whether it's formal written advice, legal, you can reach an attorney on the telephone every day, or technical assistance. So there's a lot of avenues available to interpret on a case-by-case basis. But I did want to respond to the one comment regarding scope. He's asked why, when initially we were talking about regulating blogs, and now the universe has expanded. Many comments that we got when we started this was that just looking at blogs wasn't a realistic view of what's happening on the internet, which is why we broadened it a little bit. So I wanted to respond to that. And then the second point, if you turn to the second page, subdivision H defines content, and his point that not knowing what this, the final 2 lines about, nor does it include commentary posted in response, was unclear. And I think that we can develop language. I have language to present to you that responds to that, and to try to explain that what we're talking about is when a blog is posted and you comment in the comment section on that page, those are the things that we're trying to accept out of the definition of content, because there's no assumption there that those comments would be neutral. The public's not confused about where those are coming from, and I understand that there are occasionally made by people who are paid to do so. But what I propose is on line 14, from the word commentary, deleting from the word commentary up into the period, and replacing that with, nor does it include a comment added to a discussion on the same page that the comment is posted. Happy to read
One
that
more
again.
time?
Yeah. A comment added to a discussion on the same page that the content is posted.
Do you think you're being a little narrow by saying same page? I mean, is there some other way we could say that? Because it's really about the discussion thread rather than about the page itself.
Oh, I was trying to refer to the web page. The
web page, but
okay.
okay.
So I can say that, or we can limit it to. I want to make sure that it's connected to that particular article.
Right.
Right. If web page makes more sense, yes. Okay. All right. Sorry about that. I didn't want to create less clarity. Okay. So those are all the changes, and if you have questions regarding more of what Mr. Maviglio brought up, I think that those are the points that I wanted to make sure to respond to, but I'm happy to discuss any of the others. And with that, we recommend approval.
Thank you. Are there any questions? Commissioner Wasserman.
So, getting back to the question of who this covers and who it really doesn't cover, because we had this discussion last time, but every time we change it, I just want to make sure we're still on the same page. Certain types of vendors and sub-vendors are going to be recorded elsewhere, right? They cross a certain threshold of funds, but those folks are or are not also going to be singled out for this specific reporting.
It's all the same report, so it's going to go onto the Form 460, and what's going to happen is that you're just going to get a little bit more specific reporting rather than saying the campaign paid a vendor this amount. You're going to get the specific reporting that shows where those posts are showing up.
For those entities that fall under those other section reporting thresholds, but then this is also going to capture a lower threshold because there's no dollar amount for how much you're paid.
Right. However, I'm trying to think of how.
I mean, practically how many people are going to be functioning under $500 or whatnot. But still, I just wanted.
That's true, but I think that we've linked it to 84.211 and 84.303.
I see.
So that it pulls in those thresholds.
Okay, because one of the earlier iterations, I don't think it was linked because we were talking about who are we really talking about.
That's possible.
All right then, and the other, and I brought this up before as well, but it still is a concern for me because I think, and I saw in one of the letters the same kind of discussion. You know, this has value and the reporting is important, but the point of sale communication is important, and in between is a possibility to connect the point of sale, and we say where it was posted, but we still don't say anything about under what handle or what name, etc. So again, as I had said before, you can post this thing under Sacramento Truth revealed handle, and you're not, unless there's something I missed in the changes that's going to connect it back to the reporting that says it was posted on this blog along with these 7 other things that could have been another paid posting or an individual. So I mean, I understand the quest for perfection could just lead one on and on and on, but I'm just wondering why that avenue didn't go any further.
Yeah, there are a couple things. The first would be that when you brought those points up, I don't know if it was last time or the time before, but one of the things is that by defining content, taking out a lot of those comments that you were talking about when we discussed it, when you comment under whatever name and it's and you're commenting all over the place under different names, we accepted those partly in response to your comments. The second thing is I realize that people can post under whatever name. A lot of what we're seeing here in the report is going to be who you're paying and on what website it shows up. So I think that that's going to help people see through a lot of these names, or alert them that they that there's maybe something they should look at,
right.
Or take it with a grain of salt.
And there's an opportunity for counter speech if the opposing view sees the report and says, then posts on the same site, please be aware that there's someone here being paid to do this. And then, then they have to say, but we think it's that one, but we're not so sure.
Well, that's true. And I think that getting those pseudonyms would. I'm not sure how detailed we could get into the pseudonyms, but I think that the information that we're providing the public offers a lot of information that would help the critical thinking aspect.
And one last one from me.
Yes.
We went from content to favorable or unfavorable, and I'm just thinking about when the rubber hits the road. Lawyers and amateur lawyers say to themselves, well, I wasn't doing favorable or unfavorable, I was just posting the truth. It's the truth. So
I agree, and we've talked about we've talked about this a lot, and we started off with no descriptor, and then we went to we kind of went into the express advocacy mode. I think that what we're trying to capture here is going to be obvious in a lot of cases and kind of gray in some areas, which is why we have our complaint system and such great investigators. I don't think that and advice. So the advice helps on a case-by-case basis, and people are welcome to call. The campaign is responsible for the reporting, and we're always available to explain that.
So paid blogger posts, an FBPC decision about this other candidate. That's just posting a fact, as opposed to editorial on top of it.
There's no commentary there, right?
Mm-hmm. Okay.
Yes, Commissioner Wynn.
Thank you very much. First, I'd like to thank staff for working so long and hard on this. Technology changes so quickly in this online communication. We wouldn't have been talking about this a couple of years ago, and it's going to continue to change quickly. And I think that's why we really ought to do something now, and keep in mind that it's dynamic, and we're probably going to be reviewing this again in 6 months, and then probably again in 6 months. So I appreciate Mr. Maviglio's, better get it right than fast, but number one, I don't think this is fast, and number two, as technology changes so quickly, this is dynamic, and this is going to be the first bite at this apple. I think we've, taken into account, a lot of really great comments from the public, and I'm pretty happy with the regulation as it stands now. So I would move approval of this.
We have Mr. Maviglio an opportunity,
absolutely.
and
Sorry
anybody else that's in the
Thank you.
in the audience that would like to speak. Is there anybody who would like to speak to this?
Before we do that,
Oh,
could I
I'm
add
sorry.
a question or two? I wonder.
No, not you.
Okay. First of all, thank you for doing such a careful job on redrafting this. I think, it's hard to get this perfect the first time, but we've spent a lot of time on this, and I think it's a very nice effort. I had a question that was Commissioner Wasserman's concerns or points raised, and I like including but not limited to as much as the next lawyer, but it got me thinking about that language in subsection C, and what exactly we're getting at here in terms of disclosures. I guess my question or concern were twofold. First of all, what is that phrase doing there? If we're asking people to provide information, we should tell them the information we want them to provide, or if there's something that we can't specify because it's a case-by-case kind of thing, then we should at least express in general terms what we're looking for. I for one, can't think of some enumeration that was not put in here with the following exception, which is goes to, I think was the contemplation of this last provision, where it says that the disclosure of the name of the website or the URL in which the communication is published in the first instance. The purpose of this, I take it, is to allow the public to see in the disclosure a specific identification of the favorable or unfavorable content that was posted and paid for. Is that? I mean, that's the idea, right? I wonder whether this ought to be more specific in terms of, you know, requiring a specific identification of the content that brings the posting within the scope of the regulation, as opposed to something that just has the name of the website. Because I'm not the most technologically savvy person in the room, I'm sure, but I can imagine a situation where you have a website where there's content that's not paid for and other content that's posted that is paid for, and the public's going to have an interest in knowing what has been and what has not been. So if, I guess my initial proposal here, but I hate drafting on the fly, I'm sorry to do this to you, is to eliminate the including but not limited to, or I guess take out the but not limited to. And then with that last clause, I think instead of saying the name of the website or the URL, we should say, and a specific identification of the content, or maybe we can be more specific about the content. Is that the purpose? Do I correctly understand the purpose of this?
I think that you have I think the purpose overall is to let the public know that they can go and compare what the campaign's paying for to what's showing up online. I do want to point out that we're a little bit limited by the Secretary of State's forms. It's not just what we can do, but what the forms will actually hold. I'm happy to take suggestions about, but not limited to. I put the regulation through enforcement, and they've put this in twice. so I don't know if it's helpful for them in terms of the way that they read the type of information when investigating, or if there's some other purpose. That's why it's not to place blame. That's why it's there. And I'm, if anyone else wants to comment on the getting the language, the referring to the actual comment, I'm happy to hear it. I'm a little concerned about the form. So I think that providing the website and letting people go and find that information, and then like Commissioner Wasserman was pointing out, that they could then do the analysis from there.
What is it about help me understand the logistic issue? What is it about the form that allows you to, or that would allow somebody to identify the name of the website or the URL, but not a description or more specific description of what was posted there? I don't want to pretend like I'm knowledgeable about this. I think that probably Linda Cassidy can discuss it, but the way that the forms, the way that the Secretary of State's website works, my understanding is that there's a box that we can fill up, and I'm not sure if putting all of the language that we're trying to point to would be helpful, or if it would provide so much information that people would scan over it.
Linda is here, and it would be helpful, I think, for her to comment.
Hello. Good morning. The Secretary of State's website, as we know, was designed back in the 2000, before maybe earlier. There's a specific text limit in the description box. I don't know off the top of my head how many characters can be in there, but it may be limited. And you don't want there won't be space for someone to do a long paragraph on where the commentary or the content was. So it would be much easier there. It would be better just to have a short description.
Well, with that, it sounds like this is probably, given the technological or logistic constraints, maybe the best we can do. But I do feel that, as drafted, I would be strongly inclined towards getting rid of the but not limited to. I don't think it provides sufficient guidance to regulated folks as to what we're asking for.
I'm fine with that.
I agree with that,
Okay.
actually. Yes.
So just to note, we're talking about page 1, lines 15 and 16. We take out the comma, but not limited to, comma.
Right. Thank you.
Commissioner Wasserman.
I think I previously talked in about the same section, same portion, about where, the URL where the communication is published in the first instance. And I just wanted to highlight that point again about the gamesmanship that, I mean, again, where the rubber hits the road. The first publication could be on my very teeny tiny blog with 2 subscribers, myself and myself. And the next one could be posted elsewhere, which is a more trafficked, etc. So I also saw the other direction where if we say every instance, then you've just got way too much and it becomes uncontrollable at some point. It wouldn't stop me from supporting this regulation as written with the effort that's gone into it and knowing that we are going to address this again. But I just wanted to highlight that again. Thank you.
Thank you. Any other commissioner at this point? Any members of the audience would like to come forward and speak to this matter? Yes, sir.
Thank you. Peter Warfield. As a member of the public, I have not come here particularly for this, and I'm not up on the details, but there was considerable discussion last time about this matter, including some comments of my own. So I'd like to just say a few things about what I've seen and what I've heard here. I appreciate very much the comments and the questions that are and the issues that are being raised by members of the Commission, particularly Commissioner Wasserman. So the first thing to be said is that on line 5, favorable or unfavorable, seems to me to open the door to endless arguments over whether something is or isn't favorable or unfavorable. He's mentioned one example. I just posted the truth. But another example is I just posted the facts. If the city librarian, for example, were running for office and somebody were to post information such as he acknowledged in a formal paper that he had perjured himself 3 times to the FPPC and went on in that vein, was that favorable or unfavorable? I just gave the facts. Obviously, it's arguable. So I think that favorable or unfavorable simply opens the door to endless argument and discussion, as Commissioner Wasserman said. I do think there is a concern with respect to published in the first instance or published where. I think that is a concern and something that could be pretty slippery. Why on page 2 the commentary posted in response to another person's comment, why should that be excluded and not labeled? I think that really you should have every appearance labeled. When, for example, Mr. Chafee came before you here in a real meeting in the real world, the chair interrupted him and asked him for his name. If he hadn't given it, or if somebody else were to speak without giving their name, there are ways of, there are opportunities of seeing who that is, or who knows who that person is, or asking somebody and so on, or approaching them. That's not the case online. And we know that typically comments are very frequently, if not usually, anonymous. You know, Serious Thinker 27. And something that Commissioner Wasserman said is, I believe, simply untrue. You cannot change, counter-comment in any guaranteed sense when the blog or the site is mediated or controlled by a particular individual or group. They may eliminate my comment, your comment, if it doesn't suit them, for any number of reasons or any reasons. There's no legal requirement that this be a public forum where everybody has a chance to speak and a legal right to speak, as for example here. And I do think that comments can be tremendously significant. They can be very lengthy, and they can also change the direction of the conversation, shifting it in directions that may
You have
lead
30 seconds.
may lead in all kinds of different directions from where it was going had there not been that comment made. So I think for a number of reasons it's appropriate to identify essentially every utterance in a place where others might see it, and not exclude it as you have done in H. Thank you.
Thank you very much, sir. Is there anybody else that would like to speak? Yes.
Before we take the next speaker, could I ask you to speak a little bit to the favorable or unfavorable qualifier? I know a fair amount of work has gone into this, but the discussion we're having here has got me concerned about the application of it. I would have thought that each of the instances we've discussed would have fallen within this definition, whether someone says it's the truth or the facts, that those kinds of statements that posted about a candidate would be, whether even if entirely truthful or entirely factual, would be viewed as falling within the favorable or unfavorable camp. But if that's not the case, I think we ought to get further clarification on that.
Do you want to comment?
I think it's important because it really does go to the scope of what we're regulating here.
Commissioner Escovitz, Zach Morzini, General Counsel. I think it necessarily has to be a fact-specific, case-by-case determination. I don't know that we can qualify the term content any better than with the common sense terms favorable or unfavorable. What my staff is going to do when we're asked to maybe proof a proposed posting for a committee to determine whether or not they need to report this is look at the surrounding circumstances. Okay, a committee is paying this individual to post this. Where are they posting it? What is the content of it? And generally take a look at it and make a determination. I guess, you know, if it contains factual information, is it purely factual? Are the facts current? Are these being brought up to put the other candidate in an unfavorable light? I think we just have to move forward with the realization that qualifying the term content is not going to be an exact science. It's not going to be a bright line in this area.
I guess, I mean, part of my question is, why does content need to be qualified? And, I mean, I hear you. Obviously, the staff uses discretion.
That's the conversation last month.
Yeah, I get that. I am concerned that this would impose a large burden on staff as well as on folks who are regulated by this, because any assertion of fact could be viewed as favorable or unfavorable, and you're going to be getting a call anytime anybody wants to put something of an arguably factual nature or truthful factual nature online. And so, I mean, if all we're doing here is putting in a bunch of kind of vague qualifying language that puts the onus on staff to resolve all those, or on the regulated community to reach out to staff to resolve all those on a case-by-case basis, I guess I'm trying to understand if that's absolutely necessary.
Well, I think we brought back the qualifiers to the term content because the Commission expressed a concern that they didn't want every single posting that a committee is, or an individual is getting paid by a committee to post. Senator Smith is appearing at the Folsom Rodeo and he's going to discuss X, Y, and Z. That's content. Do we need or want reporting of that? I don't think the Commission does. I think staff realizes that what the Commission's concern is people thinking they're reading a neutral posting when in fact it's the furthest thing from it. The individual is getting paid to sway a voter one way or another. So I think committees are going to keep that in mind when they do their reporting, and certainly staff's going to keep that in mind when they look at what is being investigated, or if we receive a complaint and say, look at this. We'll take a look at it. Is it serving the purpose of what we believe this Commission is after, which is to ensure the transparency and that voters have the information as to who's trying to sway them on a particular issue regarding a particular candidate. That's about the best I can come up with.
Are there any other questions by the Commission? Mr. Maviglio.
Thanks. My name is Steve Maviglio, the aforementioned Steve Maviglio, who provided the comment letter and has been working on this issue, I think, long before even the staff has been working on this issue with the Commission. I was invited here a few years ago to participate in the subcommittee's discussion. And yes, I believe we should do this right and not fast, because this is the first time in the entire nation anybody's tackling this. I don't think it's fair for those of us who work on our campaigns to spend our time talking to your lawyers to understand what it is. I think you have a duty to spell this out for people so that we know who's affected and how they're affected, and so it works for you and Mr. Winnick, who's going to have to enforce an avalanche of paperwork. That's all I'm asking here. I want to support this. I support disclosure. I've said that numerous times. But the way the language is written here, and you're having that discussion now, it's not tight enough. And I don't see the harm of holding this over another month so that staff can continue to work on this with the public. This last draft has not been circulated among the social media community. In fact, even though I testified here last year, I had to get it online to see it. So I would just ask that you talk to people about what you're doing. I do want to thank your staff. They've been fantastic with me in answering back and forth. I appreciate that, and the chair who engaged with me on the media. I'm not going to read this whole letter, but I would just say there's a couple things, and you've discussed a few of them today, that I am still not clear on. Basically, who does this regulate? Is it people that are just being paid exclusively to post, or is it anybody who works on a campaign who posts? I asked the staff that question, and the remark I got back was any paid person who provides favorable or unfavorable content. That is a much bigger scope than people that are paid to post. And I really hope you really narrow the definition of that so we know exactly who it is. I suggested saying primarily a person who's paid to do this. And many campaigns, people wear many hats, to use these name for what I do, and they do a lot of different things. So let's figure out who we're trying to regulate, and then we'll get this right. Where it's regulated, you've pointed out the URL issue. Why even put the website? If you're going to be reported from where you post, put the URL. That will solve the issue of people that have anonymous names. You'll know exactly where they published. Why not do that? There's some other issues here published in the first instance. When I'm on a campaign and I send a suggested tweet to 100 people that work on the campaign, I have no idea who's going to publish it or where. So how am I possibly going to report that? Again, it would be nice if there was some way to allow that to be reported. And thirdly, personal. You know, a lot of people work on campaigns and post stuff about their day on the campaign or something. And now that, because they're paid to do that, they're paid to work on a campaign, that has to report it. I don't understand what you're trying to get at when somebody's personal page that has their name on it, why they have to report that. It seems just over-regulatory to me, and I say that as somebody who generally believes in a lot of regulation.
You have about 30 seconds left.
And lastly, the question about response. Again, that's not clear to me. If somebody posts something on somewhere and I respond to it on another website, that apparently is not considered a response, or is it? It's not clear what it is. So again, I'm just looking for more tightening of some language here. I think you're almost there. I think everybody's done a great job getting where you need to go, but there's a lot of language, as you're discussing today, that still needs some work. Thanks.
Thank you very much for your comments. I would like to correct you about one thing. Actually, this is one arena where California is not the first, and I believe it's Maine that actually requires bloggers to disclose themselves, not just the campaign committee. There's been a Court of Appeal decision in the federal courts upholding that.
Actually, Madam Chair, the City of Los Angeles has had this ordinance in effect for almost 2 years now. So we're not exactly the first.
More so, the LA Ethics also requires the bloggers to.
Oh yes, and they actually mandate that the bloggers disclose on their posting that they are being paid. Here, we don't do any such thing, but if they voluntarily choose to self-regulate like a lot of bloggers say they do, they can avoid the reporting altogether. So there's that.
They don't. They're not
reporting
that the committee
their payment to the blogger.
This is solely the committee. Right.
And the sky hasn't fallen that I know of.
Would you like to respond? Could you respond to any of those matters? And you could stay at the podium if you wish to.
Thank you.
To have a back and forth.
I do appreciate the in Mr. Maviglio's comment letter, he asked us to insert the word primarily, and I think that has the potential to create a situation where people are trying to figure out who's primarily paid to do what. I think that like he said, many people are wearing many hats and primarily would either whittle it down to no reporting or cause the committee to try to figure out who's doing what in a as their primary purpose. I think that Mr. Maviglio and I have been back and forth on this, and I think that the main point that I tried to convey was that we're not trying to be unreasonable, and in terms of the first instance, I don't think the campaign needs to figure out a timestamp on each posting, but that the point is that we're trying to get the information to the public, and if the exact same article appears in 3 different places and the campaign reports one of those places, even if they didn't get it exactly right on where it came up first, the public has a lot more information than they had before. If they want to search that author or take search terms from the article, they can find the other places that I don't want to put the onus on the public, but I also don't think that we should just stop what we're doing because the internet works so fast. I think that stepping into the ring will at least get us someplace.
And it's not just the onus on the public; the press is also available to do that as well, right?
Right, and
once
as we
that
see
information is out there,
exactly, and as we see in many other areas of the Act, the people who are policing this, Mr. Maviglio mentioned that it's a self-policing industry. There's that. There's people who are opposed to a certain candidate who want to see, something shows up and they want to know. The press, the public, people are getting more savvy about getting that information. We just want to give them a tool. Finally, I think that Commissioner Escovitz had comments on whether or not, or what a comment is in terms of the exception under the term content. I appreciate the discussion that a lot of comments do change the discussion, but I think that first of all, the language that we came up with to limit those, to not call it a commentary, but to really just use the noun comment and limit it to appearing on the same page. Isn't that where if someone posts a counterpoint to a blog on his or her own website, it doesn't fall within this exception. This is it's limited. It's intended to say if you're going to comment on that same page in the comment section, you don't have to report every time you're looking around and commenting on blogs. It's meant to be a reasonable exception, and it's meant to respond to or reflect that people reading these blogs, the assumption is that what we're saying is the assumption is the neutrality is presumed to be in the article itself. I don't think that people assume that those comments that follow are as neutral, whether they've been paid for or not. We're just trying to give the public some help in making these determinations.
Do you have another comment in response?
Just 30 seconds.
Sure.
First of all, none of those regulations that you spoke of, which in Maine nor Los Angeles, are nearly as sweeping as this. B, most of the discussion is talking about blog posts. There are many other platforms that people use, Twitter, Facebook, and it's been very odd and incompatible to put this regulation on some technologies like SocialBots, which doesn't address it all, which is 50% of the web traffic. Nobody knows what to do with that because it's software, it's not a person. And thirdly, I think it would be really helpful, since there still continues to be some confusion about who is regulated on this. Is it anybody on a campaign who gets paid, or is it people that get paid to publish? And that's cloudy. Thank you.
I appreciate your question about that, but I don't really understand how there can be confusion about that, since it's stated quite clearly here that it is paid to provide this content. So even if you're working for the campaign, if that's not your job, then, and you're not paid to do that, I honestly don't understand the confusion that you're suggesting exists and no one else has raised.
If I can respond to that,
Sure.
I discussed this with Heather in an email in which her email says to me, and I quote, "Any paid person who provides favorable or unfavorable content." And I think any user of the internet who works on a campaign and gets paid could be in that category, including sub-vendors, somebody who posts something for a social media company. And is that what you're trying to do here? Or are you trying to get people who are just posting and that's what they get paid to do?
Would you like to respond, please?
I don't see the confusion myself, so I think it's written fairly clearly, about as clear as we can get it. An individual that's being paid to provide favorable or unfavorable content.
Can I give you an example so hopefully I can be unconfused?
Sure.
If I am a paid campaign worker in the city of Fresno and I work for the Heather for Governor campaign and I get paid $600 for that work, I go home, I post on my personal Facebook site, "Had a great time today campaigning for Heather in Fresno. She's the best candidate for the job." Now, I wasn't paid to do that, but I was paid to work on the campaign, so would that be required?
Mr. Maviglio, I think you answered your own question. You weren't paid to do that.
That's my confusion, because that's not what it says. Any person who provides favorable or unfavorable content.
No, you just skipped over a word. You
No,
said any
I'm quoting
person who
from the
pays
staff
who
email,
provides.
the person who wrote this regulation, who said any paid person who provides favorable or unfavorable content.
Well, I think that response is not as clear as it should be. I think if we stick to, but the language in my mind is fairly clear. But that's me, because it says pays a person to provide, so not any person who provides. But if you're paid to provide it, I think is the qualifying language that to me narrows the focus as to what the commission is after here.
Okay, and I would just suggest to you, if the person who wrote this and you and the commissioners don't agree on what it is, how do you expect those of us who have to report this understand?
You know, I actually think that maybe her response was not as clear as it could have been. I do not believe that, and she can speak for herself, but I don't think we need to get into this right now, actually. I think we should move on. But I think that there's quite a bit of clarity, and this meeting alone will serve as legislative, assuming it's passed, legislative history for that.
Yeah, I mean, to that point, I think that obviously the language and the regulation, should it pass, would control on the scope of the regulation, regardless of any prior emails.
Okay, as long as that's clear, everybody, I'm good with it.
Sir, just 30 seconds, please, to respond.
Peter Warfield again. I think that the previous speaker said that what he was told by the staff is quite different from what it says here. When a recipient committee pays a person to provide favorable or unfavorable comment, and I would like to see that at least say when somebody who is paid by a committee provides comment. It may be a person who's paid by a committee to sweep the floors, but if they go home and feel the urge to respond to something that they see, I think it ought to be labeled. And frankly, I also think they ought to give their identity. This, I think, the way that it's stated now opens the arguments to, was this person paid for the purpose of providing this comment or that comment, or was he actually somebody who was paid, for example, to be the candidate's spokesperson, and this posting was just a sort of a frill on the side, a secondary or tertiary activity. Thank you.
Thank you.
Madam Chair, I just have very briefly,
Commissioner
not a
Watson.
question, just a suggestion. When we were talking about H, about commentary posted in response, I noted that you put clicking on images to, quote, cast a vote to sort of indicate you're talking about a term of art. Perhaps you could do the same thing with comment in quotes on another's post. Because I think there was the question of whether or not that was to be interpreted as covering counter speech on a different blog.
As I understand it, the language that you proposed today would limit it to a comment added to a discussion on the same web page where the content is posted, right?
Mhm.
So we've already, I mean, you're already making it clear that content, the comment, whether it's in the form of a comment box or a note to the author or whatever, that's the limited exception here is going to be narrowed to the situation where that comment is added to the discussion on another website or another web page, right?
Right.
Okay. I'm satisfied that narrows that exception so it doesn't become something that potentially swallows the rule.
Yeah, that was just an alternative way of saying it.
Okay. Thank you. Yes, please.
Good morning, Betty Ann Downing, California Political Law. Not here on behalf of any client. I deal with the nuts and bolts of reporting and what actually has to go on the form. So I have a question on C. It's line 16 on page 1. It says, disclose the name of the person providing content. Person is defined very, very broadly in the Act itself. So when you mention person here, is this, for example, we pay a company, so you want us to disclose the company, or do you want us to disclose the name of the individual who's actually doing the writing? Who or what are we to disclose? It's a clarifying question. Thank you.
Thank you.
I think that individual probably would offer more information there.
Right.
Yeah. Yeah. I didn't mean to muddy that with a broad definition of person. And if the commission agrees, we can strike that. Insert individual.
Individual. Line 16. Okay. Is there anybody else that would like to speak to this? Yes, sir.
Since I've been sitting here, my name is still Daniel Pillay, and I still do work for Consumer Watchdog unless something happened that I'm not aware of. Just as a clarifying point, the FTC also requires paid product bloggers to disclose payment by companies that they blog for online in another environment. I addressed this commission 2 meetings ago in San Jose in strong support of the proposed regulation. I came from San Jose, so perhaps I can get a ride back with the mayor's motorcade and not hit traffic. To be here to thank the Commission for continuing to push this regulation through and work to bring sunlight to as much of the political spending process as possible. Like you guys have said, you've been at this for over a year with multiple opportunities for public input, both here and around the state, including in San Jose. And it's time to bring this regulation home. The proposed rule isn't about outing satirical accounts, but is about ensuring that the voting public knows that paid bloggers, no matter what side of the political aisle they are on, should be viewed through the same prism as political advertising and direct mail pieces, and not simply as purveyors of objective news. Furthermore, as Consumer Watchdog said in our official support letter, is that mine? Okay. You should turn at J Street, apparently. Furthermore, as Consumer Watchdog said in official support letter, we wish to specifically express our strong support for the key amendment proposed last meeting that would waive the campaign reporting requirement for those paid bloggers who agree to disclose that they have been paid at the original point of contact with the public. Transparency where the voters need it most when they read or see a message should be the Commission's end goal. Again, we commend the Commission for its continued work on the subject and hope that this is just the first step in the process of realizing an end goal of real-time disclosure. Thank you.
Thank you very much. Is that it? Anybody else? Okay. What is the pleasure of the Commission? Is there a motion? Excuse me?
I'd move approval
No.
of this this item.
Eric will let
I'll second.
Commissioner Casher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel.
Yes. Thank you. And I do appreciate all of the public input that we've had today and for the over 2 years since this has been discussed before the Commission. And we certainly, as with everything else, will be sure that it is enforced in a reasonable, thoughtful way. Thank you. Okay. The next item is item 25. petition to amend Regulation 18521, distribution of leftover funds by ballot measure committees.
Yes, good morning, Madam Chair. Zach Morzini, General Counsel. Today we have a petition by Tom Willis of the Rimcho Law Firm under the Administrative Procedures Act to amend Regulation 18521.5 to permit the distribution of funds upon the termination of a committee to a political party. So with that, I'd like to invite Mr. Willis up if he's here.
Thank you.
To give you a summary.
Thank you very much. Thank you, Mr. Willis.
Thank you. Good morning, Commissioners. I think it's still morning. I just wanted to very quickly discuss why the California Democratic Party has requested this regulation change. And that's that the party received several inquiries and has received several inquiries over time about whether they could accept leftover funds from candidate-controlled ballot measures. And they were surprised to find out that they could not. Just as a way of backup, the general rule with respect to every other type of political committee that is out there, so whether it be a candidate-controlled candidate committee, a ballot measure committee, even an IE, an independent expenditure committee, a general purpose PAC, all of those types of political committees can already give leftover funds to a political party to their non-candidate committee. And so we just ask that that same rule that applies to every other type of political entity be applied to a candidate-controlled ballot measure committee. We think that the prohibition that we are talking about today was a result of a 2009 regulation, and I think this was one of the unintended consequences of that regulation because this particular application wasn't discussed as far as I'm aware. And the concern related to that 2009 regulation, however, was about the circumvention of contributions, and that's simply not implicated at all by this proposal. So I'm happy to answer any questions if the commissioners have any for me.
Thank you. Are there any questions by the commissioners?
Yeah. I have a general question regarding, it's a practical question regarding enforcement of this particular petition. Your letter is very instructive, Mr. Willis, as it relates to the separate accounting. I'm curious. The California Democratic Party is a sophisticated party, obviously, and it makes sense where you have a separate operating account and then a separate account for candidate support. I'm thinking of how might this apply to a less sophisticated, maybe local party that doesn't have a separate accounting system, and then from an enforcement level, how would you go about determining whether or not enforcing this so long as language, so long as the funds will not be used to support or oppose a candidate. If there's money being transferred over, the leftover funds are being transferred to the CDP, it's going into the operating account. Presumably the money would be used out of that account, would not be going to any candidate-specific expenses. A forensic accounting could determine that, but if there isn't that type of delineation for other parties, local and whatnot, how would we know how that's being used?
Commissioner Kasser, thank you for that question. I think even the local parties are sophisticated in terms of the regulations that are imposed on the state party are imposed on them as well in terms of what funds can be used for which purposes. You have some instances where funds that were raised under contribution limits coming to a party and some funds that weren't. So I don't have any hands-on experience. Maybe Mr. Willis does, and he can speak to that.
Yeah, I think that that's exactly right, that there's a kind of a default requirement that they separate into those accounts simply because the money that could be used to support a candidate is subject to contribution limits, and so therefore they have to separate those out, and certainly those can be understood easily through any kind of accounting process. But by the mere fact that there are contribution limits to any party where the money goes to support or oppose a candidate, you keep that money separately.
Are there any other questions? Is there anybody else that would like to come forward and speak to this matter? Is there a motion?
I will move to approve item 25.
Second. Commissioner Kasher?
Yes.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
No.
Commissioner Wynn?
Yes.
Chair Ravel.
Yes. Thank you. Okay, I want to take the pulse of fellow commissioners since it's noon. Do you want to take a slight break, or can we sort of go through a couple of the items up until the hearing to get them out of the way and then have a break before the... Okay, good. That's great. Thank you. All right, so item 26 is the approval of the campaign manual major donor committees. And I don't know, do you have the desire for a presentation by Ms. Cassidy?
Unless she wants to, I'd be happy to move approval of
Okay.
the Campaign Manual 5 Major Donor Committee.
Approval sounds great.
That's my man. And is
well
there a
done.
second?
I will second.
Okay.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes, assuming there was no one who wanted to comment.
Oh, right. So sorry. I was
I'm
getting so
hoping.
excited. Is there anybody in the audience that would like to comment on this matter? No.
I vote yes.
Thank you.
Commissioner Wynn,
Yes.
Chair Ravel,
Yes. Okay, the next item is item 28, I believe, in the matter of Citizens for a Voice in Government Major Funding by Investment Manager.
27.
Oh, 27. Which one is
Appointment of a vice chair.
Oh, there's nothing in my, yes. Yes, this is at my request. As you all know, at some point perhaps I may be vacating my position and going to the Federal Elections Commission, and it appeared to me that it would make sense to have a vice chair appointed by the rest of the commission, and that person could act in the event that there has been no replacement appointed by the governor, since no one knows when it will occur. So either the appointment or my appointment. So I would suggest and move that our senior member of the commission, Sean Eskovitz, be appointed by the commission to act as vice chair.
I'd second that.
I just had a question.
Yes.
Just want to make sure this is something we can do.
Absolutely.
Okay.
Commissioner Kasher,
Yes.
I don't know if there's anybody that would like to comment on this matter. Okay. Gary?
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel.
Yes. Yes, Commissioner Eskovitz can vote on this because there's no additional money that goes with this honor.
I thought that through before I
That's-
voted.
That's right.
Not before I accepted.
Thank you. I appreciate your willingness to do this. Okay, item number 28 is in the matter of the Citizens for a Voice in Government, and excuse me.
Madam Chair, I just want to remind you this is a closed session item, so he's going to give a presentation.
Right.
And you can deliberate. in
Well,
closed session.
it is a closed session item, and you could make your presentation, and then the commission can determine if, in fact, they would like to deliberate in closed session, or if we can just, act on this matter in public. Okay, Mr. Winnick.
Madam Chair, members, Gary Winnick, Chief of the Enforcement Division. This matter is a little bit unusual in the way it's coming to you. Generally, as you know, we do administrative enforcements. We've chosen not to do many civil enforcements just because the process and the time of doing civil litigation on most of our cases, I think, would negatively impact the speed with which we could move on the cases. However, we do want to do civil prosecutions where there are certain cases where we feel the penalty limits that are imposed under the administrative section of the Act aren't sufficient to cover the conduct. And that's the posture that this case is in. This case evolved rapidly, really since our last commission hearing. We received a complaint that a ballot measure that was active in Sacramento related to the ongoing arena issue was not having proper disclosure as to who was paying for, or what group or person was paying for the signature gathering effort of a ballot measure that continues to this day to be actively being worked. So we did what we do. We approached it as we do many of our pre-election cases, which is if there's imminent public harm, the direction we've received in the commission is that you want us to try and make a difference when it matters, which is while people are considering issues and before the election, to try and engage. And so we engaged on this one. We asked certain parties that are detailed here to identify who was disclosing or who was paying for the gathering of these signatures. And in this case, we did not get compliance. And much like our case from the 2012 election season, when we don't get compliance, we move swiftly to file an action in Sacramento Superior Court to compel that compliance. So once we filed that action, we did get a swift settlement. We have the disclosure of Chris Hansen as the person who paid for the signature gathering. And so this is our negotiated settlement with Mr. Hansen. For us, the case is in a different posture because of the fact that we had to compel compliance through a court process. That to us put us in a different vein and why we're seeking a higher penalty. It's similar to an administrative judgment in the sense that we've agreed to the language that's contained within it as well as the penalty amount. So aside from the fact that if this is considered by you and approved, we will have to file the judgment in Sacramento Superior Court. Other than that, there are a lot of similarities to the administrative process in terms of the way it was negotiated, the way the facts are presented to you, and the penalty amount. So that's how the case got to you today. It's up for your determination. If you do decide to approve it, we'll then go and file it either later today or tomorrow with Sacramento Superior Court to enter the judgment.
Thank you. I guess let me ask if there's anybody that would like to speak to this matter that's present here today. What's the will of the commission? Would you like to retire to closed session to discuss this matter, or do you feel comfortable to just proceed?
Commissioner Wasserman, I feel comfortable proceeding.
Okay. Any concerns? All right. So, are there questions of Mr. Winnick by the members of the commission with respect to this?
I just had a procedural question. Does it need to be filed with the Sacramento Superior Court because it's already venued there, because there was already a motion to compel, if you will, previously filed, or do we need to do that in order to, because of the amount of the stipulation?
Sure. There actually wound up being two actions here if we do file this action. Originally, the action was against Loeb versus Loeb, which is a California law firm, because our investigation had sort of led to that being the final stop for the check. The suit we had was against them, and then the injunction we were looking at to compel them to disclose it wound up being dismissed after we had the settlement and disclosure. So this action is actually against different parties because these are the actual donors. So this would sort of be a fresh cut at it.
Okay. Well, I'd like to, add my voice to what Gary said, or Mr. Winnick said about this case. The extraordinary speed that the commission took in enforcing this matter is consistent with what we think is important, and that is to give information to the public. I mean, that is absolutely our charge and our mission about who is funding campaigns and political activity in California, and the fact that this was done with such speed so that it gave information to the public when it was needed so that they could make decisions about issues is not only a good thing and consistent with what the purpose of our work is, but also very much like what we did in a number of cases prior to the election in 2012, not just the one that received all the headlines, but 24 others. So I just also do want to commend the Enforcement Division for working so quickly on this.
If I may, Madam Chair, take a moment of privilege and just, I get to sit up here and take credit, but our staff did great work, in particular Dave Bainbridge, our staff counsel, and Lee Myers, our staff investigator, who really deserve the credit for it.
Thank you. Is there a motion?
I actually just wanted to say to Mr. Winnick and the
sorry.
Enforcement Division, they'll often hear from me questions, etc. I think it's only fair to say, yes, this was exemplary.
Thank you very much.
I'll move approval.
I'll second.
Oh, go ahead.
Yes.
Commissioner Eskovitz?
Yes.
Commissioner Wasserman?
Yes.
Commissioner Wynn?
Yes.
Chair Ravel?
Yes. Let the next item going back and forth from 29 is 29 me? Okay. Can we instead go to perhaps the administration reports and item number 30, and I don't know whether anybody has any questions or if we could just accept those reports.
I did just have a question about the legislation.
Oh well, yeah, we can do that one separately.
Super.
I'm looking at the rather than the legislative update,
Okay.
just the report.
Madam Chair, I have a very brief comment on legal division.
Okay.
It was just that I'm conducting some outreach myself, and I'm visiting filing officers in LA County, and they are very in favor of as much training as they can possibly get. They love in person, but they like the fact that webinars are available as well. That's all.
Great. Thank you. Is there, by consensus, can we just accept the report?
I think Commissioner Wynn had a question on the
On
legislative
the
report.
legislation, we're doing that separately.
Oh, okay.
So, hearing no objection on the legislative report, would you like to ask your question, Commissioner
Well,
Wynn?
I just knew that this was dated September 3rd, and there was another 10 days of session, and I just wondered if you could update status, like which bills ended up on the governor's desk, because a number of them were pending in committee.
Sure. I have to remember, but so I know SB. I can just go through in the order that they're in here. SB 27 is a 2-year bill.
Okay.
AB 409, we're very pleased to report, is at the governor's desk, and we're excited about that project. We'll be coming back to the commission with a lot of information about that.
With a unanimous vote.
Yes, sailed through both houses unanimously. AB 552 is also in the governor's office. AB 914 is a 2-year bill. AB 1090 is also at the governor's office, and that was, I think, a surprise to some people. And then SB 2 is a 2-year bill. 26 is a 2-year bill. AB 45 is a 2-year bill. And AB 800, a 2-year bill. And then SB 3 is also at the governor's office.
Thank you.
I'm sorry. Maybe Suki can talk. If you have questions about the bills, the
No,
neutral bills.
That was, I really just was kind of curious how many, passed
Yeah, so
through and
basically,
went
it's
on.
basically
Just-
4 bills, I think. So 409, 1090, SB 3, and AB 552.
Thank you.
And we'll be continuing to work with stakeholders and other people on the 2-year bills as in the interim, so that in January, we can be ready to go. So there were some concerns that were raised on some of the bills, but we want to get those addressed and be ready to go in January.
So do we expect governor's signatures on the 4 bills?
Yes. Well, yes. we're in conversation with them, but I think we'll be looking at that. And the chair has sent a support letter on AB 409, and we're working on letters for the rest of the bills that are at the office.
Thank you.
Thank you. Okay, so we're accepting the report by consensus. The next item is item 29, which we will take a break and permit the parties to come and sit at the front table, and so I don't know, maybe 15 minutes. Is that okay? So about 12:30, if everyone can come back. I do have one comment with respect to that item, which is that there was a letter submitted by a non-party that because it is a public record, it's in the record, but because this is a different situation and this is an administrative hearing, it is not appropriate, in my view, and I've confirmed with counsel, for the commission to consider that letter. So no one needs to respond to that particular letter. Thank you. Thank you. We're reconvening for the item administrative hearing in the matter of Chuck Reed, and I believe that what would be the order of...
if I may, Madam Chair,
yeah.
Gary Winnick, Chief of Enforcement. Maybe I'll set the stage before we start, just so you can understand how we got here. Mr. Maynardi, this is Jesse Maynardi, who's representing the respondent, Chuck Reed, and Erica Boyd as well. The structure we've agreed to is to have us provide sort of an opening argument. They'll provide a reply, and then we'll provide a response to that. Maybe I could talk for a moment just procedurally how we got here. Mr. Maynardi and I both decided it might be a good idea to set the stage. And please, of course, if I say something you agree with, by all means, jump in. Since it's a day for unusual things before the commission, this is probably the most unusual of all. Generally, when enforcement proceeds with a matter and someone has an issue that they want to avail themselves of their administrative due process, we first do a probable cause hearing. After the probable cause hearing, we then issue an accusation which take to you, the commission, as you've seen a couple of times, and then we ask you if you want to hear the issue yourselves or send it to an administrative law judge. From my understanding, and there's probably better historians out there than I am, it's been around 25 to 30 years since the commission has ever heard a case in and of itself. And generally our recommendation is to send it to an administrative law judge. A lot of the reason for that is generally there are issues of fact that need to be determined by an administrative law judge. In this particular case, there really isn't an issue of fact. We've submitted you a stipulated statement of facts. Really none of that is in question. But we do have a disagreement as to what the act means in the context of those facts. So in the issue of sort of efficiency, and really, as you know, once you go to an administrative law hearing, the administrative law judge simply makes a recommendation to you, and you have to then determine to accept, reject, or modify that anyway. So by mutual agreement, we decided it might be best just to bring this narrow issue before you. The agreed upon vehicle to do that was to have an administrative hearing of sorts before you directly and skip the administrative law judge. There was a probable cause hearing, as you have in your packet. There was a finding of probable cause made. An accusation was issued. We filed it. A notice of defense was filed. That process was followed as is outlined under the Administrative Procedures Act. But we've waived certain things like putting on witnesses and other things because we have the stipulated facts, and we just want to focus on kind of this specific issue of law. So that's kind of why we're here today. You need to deliberate this, obviously, in closed session, but we're going to provide an opening argument, a reply, and then a response to that. So absent any questions on procedure, maybe we'll just sort of roll into what the issue is.
With respect to the issue about facts, though, the fact
Sure.
that you have stipulated to the facts,
Right.
is it therefore outside the scope of our ability to ask about certain background facts that might weigh either on penalty or on some other matters?
My understanding, and again, please correct me if you have a different one, is that we really are limited to the agreed upon facts. We negotiated those, so unless it's something that I think we would both agree on, I would say we're sticking with the stipulated 2 facts.
Okay, because we can get to that then later, because I do have some questions about facts.
Sure.
Myself.
Okay. Do you have anything you want to add to the procedural to that question?
No, just Jesse Minardi, Sutton Law Firm with Erica Boyd on behalf of respondents, and I just did want to thank the Commission for taking this step, because I think the one thing we do agree on is that this is the appropriate forum in lieu of an administrative law judge when we have a question of law, really. And hopefully it can be a model for future matters handled efficiently in this way.
Great. So to start, this case is really dealing with a very important issue. The case originated out of the 2012 election, and much like we've sort of discussed today, we saw an issue that pre-election we believe needed to be addressed immediately, or it would sort of be too late after the election. And the issue was this. Prop 34 set in place some limits on campaign contributions. It restricted a candidate-controlled committee from contributing to an independent expenditure committee. That was placed in Section 85501 of the Political Reform Act. So the facts of what happened is Mayor Reed had in our opinion, a candidate-controlled committee, but certainly a committee that he was exerting influence over, that made a contribution to an independent expenditure committee to support Rose Herrera. Rose Herrera was a candidate for San Jose City Council. Mayor Reed already made a $500 contribution directly, and they do have local campaign contribution limits in San Jose. So this was $100,000 moving, which was a significant amount of money in a local race. Rose Herrera wound up winning that race. So when we received the complaint about this contribution that violated Section 85501, we did our analysis as we do for all of these, from Steve Hansen to Arizona to all of them, which is there something that clearly indicates that we should intervene? We take our role very seriously in not having an impact on elections. I mean, we view that as primary importance and a counterweight to the Commission's direction that we get things done while it matters. So the public has information, contributions are made that are illegal, and that disclosures are made during the period of the election, so the public has that knowledge, and no one, the purposes of the act are being fulfilled, and no one's getting sort of an unfair advantage in an election. So in analyzing this, to us, the statute is really quite clear as to what a candidate is, what a candidate control committee is, and that therefore this contribution could not have been made. So what we did was inform both parties, both the recipient of the contribution and the maker of the contribution, that the money needed to be returned. Part of the money had already been spent by the Independent Expenditure Committee that was supporting Ms. Herrera, but they immediately ceased spending funds and froze those, if you will, and then they immediately started providing proper disclosure on the campaign communications that they had put out that were related to this particular contribution. But the contributor, Mayor Reed and his committee, asserted a different point of view as to what the statute meant. So going forward, we didn't file an action to sort of compel at that point, and we went into sort of a regular investigative mode to pursue the case. However, our position really hasn't changed in any way, in that we believe the statute is very clear. The advice we've given over the past 27 years has been entirely consistent with it, and that there really isn't much debate at all over what was required. I don't believe that Mayor Reed made in any way a bad faith contribution, if you will. It was disclosed publicly, so it certainly wasn't hidden in any way. But I do believe that he is incorrect on his interpretation of the law. And that really is what we're here today to get the Commission's guidance on, is the Enforcement Division's perspective on what this series of statute and regulations mean correct, or are we not? And then there are some other defenses they've raised that I'll talk about in a minute that are also related.
Did you say, I'm sorry to interrupt, did you say that the Commission learned about this through...
There was a complaint filed.
A complaint filed, okay.
Right.
And so the reference you just made to public disclosure of the contribution was when, or in what capacity?
I believe it was made through a late contribution filing report, but it was through a campaign statement. I honestly don't remember the vehicle.
Pre-election statement.
Pre-election statement, but it was disclosed before the election in the proper manner. Thank you. So what I'd like to do is just briefly, since I know you have very voluminous briefings from all parties, is just kind of walk you through our perspective as to why we feel the statute's fairly clear, talk a little bit about their defenses and why we think those are not valid, and then give Mr. Mainardi a chance to give you his perspective. I know how much the chair loves PowerPoint slides, so I've limited myself to 2 brief ones, only because I think there's some value visually to seeing the chain of thought we have on it. Can you go to this one? So the issue is really whether or not Mayor Reed retained the status as a candidate. I think we both agree, and I'm sure Mr. Mainardi will tell you if he disagrees, that if he is a candidate, that he did in fact violate Section 85501. I don't think that's really a question in dispute. The question in dispute is whether or not he retained the status as a candidate under the Act. And the Act, really, like all laws, has its own set of definitions. So you can't really apply just sort of the common meaning of a word to it. There's actual definitions and regulations that interpret it, and that's really what guides what people need to follow as they're engaging in activity that's regulated under the Act. So the first one is Section 82007. That really just defines what a candidate is and when they retain their status. And it says, an individual who becomes a candidate retains their status until such time as that status is terminated pursuant to 84214. So if you take that and go to 84214, 84214 says you terminate your filing obligations pursuant to regulations that were adopted by the Commission. So to further Section 84214, the Commission adopted Regulation 18404. And 18404 really is quite clear from our perspective as to what that means. It says, pursuant to 82007, a candidate, and it says specifically which term includes an office holder, files his campaign statements until their status as candidate is terminated, and your status terminates when the individuals terminate all his statements and they've left office. Mayor Reed was still in office. He still had filing obligations and thus was a candidate. The second part of that is even more clear. It talks about candidates or office holders without committees. That means you still file the Form 70, which is when you're below the $1,000 level for filing the more advanced disclosure forms. And it says your filing obligations terminate for any calendar year. The Form 470, which is the below $1,000 threshold, was filed if the candidate lost, withdrew. So if you have someone who ran for office and then lost, you can terminate your filing obligation. But that's not Mayor Reed's situation. He was still retained office because he won his mayoral election. Or the individual left office and the individual ceased to receive contributions. So for both of those versions, you have to have left office in order to terminate your status, your filing obligation, and thus terminate your status as a candidate. All that from our perspective is very clear. You can go to the next slide. To help people interpret the Act and to know what it says, obviously we do what the Commission has always done, which is put out both advice and opinion letters. We took a brief look to see how many letters have referenced this particular issue. We really stopped counting at 62. There have really been almost innumerable advice letters put out. There was a single opinion in Ray Liu that was put out in 1987, but we counted over 62 advice letters over, if my math is correct, a 28-year period where this issue has been addressed. One of Mr. Mainardi's arguments in his brief talks about some of the timing of all this, and I think it's important to consider that too. The regulation 18404, the section we're talking about, D, was actually put in place in 1999. So if we look at the timeline, In re lieu was 1987. If you see on that chart, there was advice consistent with that through 1999. The Commission then formalized that advice in 1999 and then has advised that way consistent with the plain language of the regulation through the present day, just an extraordinary number of times. I thought it was interesting before when Ms. Presley got up and was talking about the definition of person. I thought that actually illustrated one point that was made that I think needs to be clarified. Mr. Mainardi said in some of his arguments that 85501 doesn't specifically relate to 18404. But really, I don't think that argument holds weight, only because the Act has to be read as a whole. So if we put the word person, for example, in the Blogger Reg, there is a definition of person that is contained in the Act already, and it has a certain meaning. So when you chose to take person out, you're making the choice to decide which pieces of the Act apply to any other. The Act's a constantly evolving process. We do regulations and statutes even through the past 2 hours. But a lot of the definitions and the words in that always relate back to the rest of the Act. So the definitions we have don't need to be specifically applied to every single regulation. They're there to apply throughout the Act. I think that's really just a basic point of statutory construction. It's certainly how we've applied the Act in our 35-year history. The issue here, though, is incredibly important because Prop 34 was put in place to limit the amount of contributions that were made by candidates. And the people passed that initiative, the people of California passed that initiative and asked us to interpret and enforce it. And, the situation, the factual situation here is kind of an illustration of contribution limits at the local level, but then giving, the math is going to be too hard for me, but an extraordinarily larger percentage of that amount of money to an independent expenditure committee, sort of getting around the limitations that we tried to put in. Really, regardless of whether you like or hate campaign contribution limits, the fact remains that this was passed by the people of California. It exists in law, and it's designed to restrict the amount of money that a candidate can provide to other committees. Plus, in the enforcement of the law, it's extremely important that everybody play by the same rules. This was a competitive election. The Enforcement Division has no preference in the election, nor does, I'm sure, the Commission. But it is important to us that everyone play by the same rules. If someone's allowed to give a $100,000 contribution and everyone else isn't, that gives someone a really distinct advantage. So the fair application of the rules to us was incredibly important, and part of the reason we acted, or at least attempted to act prior to the election, to intervene. I just want to briefly touch on a couple of other issues that were raised by Mr. Mainardi in his defense. I'm sure he'll have a chance to discuss that as well. He raised the act of whether or not this particular statute is unconstitutional, and he's asked you to weigh in on that and find the statute unconstitutional. I would say two things about that. One, I do not believe we have the authority to do that. And two, even if we did, I don't think that would be a wise course of action. First is just under the state constitution, Section 3.5 of Article 3 lists out, well, first it gives a prohibition on an agency, an administrative agency, from declaring a statute unconstitutional or unenforceable. The only exception to that is if there's an appellate court ruling that has made a determination that the enforcement of the statute is prohibited by federal law or federal regulations. Mr. Mainardi started a specific case from 2005 that the Commission engaged in, but the facts here are 100% different than they were in 2005. In 2005, there had been a Ninth Circuit opinion on that very same issue, plus an injunction against our statute. The appellate case from that issue dealt with a Nevada statute, but we had also had active litigation on our statute that had an injunction prohibiting us from enforcing it already. which is why it didn't violate the state constitution when we acted then. Now we really don't have the ability to sort of unilaterally decide for the court what is or is not constitutional. It's up to the court to make that determination and not to the commission unless the court's already ruled and we are sort of enforcing their order. So I don't believe we have that authority even if we were to choose to do it. Even if we had the authority, though, I think it would be an unwise course of action. I mean, again, this was passed by the people of the state of California who expressed their preference that the candidates' contributions be limited in the manner that they passed it in through 85501. I think it would take an extraordinary act for the commission to decide that that is no longer valid and in fact is unconstitutional and invalidate the will of the people. Certainly I wouldn't want to do that through an enforcement action, but rather if we were going to choose to do that, to a minimum have public hearings. I think all this is moot anyway, because when you're the subject of a statute of any type, you can't unilaterally decide I'm not going to follow that because it's unconstitutional. There's a process for doing that. He can file an action in Superior Court and then through an appellate process to try and invalidate the statute. He has standing because he was a candidate who was subject to this act. He may do so after this hearing. That's certainly a possibility, but that's something we can litigate on a separate matter. This is really an enforcement case. I don't really think he is entitled to the luxury of declaring a statute unconstitutional and thus he not be subject to it on his own volition. I don't think that's what happened here either. I honestly think he looked at the plain meaning of the statute. I don't mean to put words in his mouth, and we'll hear from him in a moment. But I think he looked at the plain meaning of am I a candidate, and under the plain meaning of am I a candidate, well, no, I'm not running for anything, I'm termed out. He called for advice for the commission, but some of the key facts that would have given them the right information weren't presented. Again, I don't think that was done with the intent to skirt the law. I think calling here was an attempt to comply, but it doesn't really change the fact that the law is what it is and that his actions violated the law. So what we're asking the commission to do is to really just apply the plain language of the statute and the regulation and all the advice we've given out over these past X number of years. Recognize sort of the gravity of having a fairly substantial contribution made in a way that, you know, defeated the purpose of Prop 34, but also gave that particular campaign an unfair advantage. And just recognize that the act was violated and impose a penalty that you think is consistent with the level of public harm.
So we're being asked not only to determine whether the act was violated, but both parties agree that this is the forum for determining the administrative penalty if in fact the act was violated. Is that right?
Correct.
So, I mean, you mentioned, maybe this is where Commissioner Ravel was going, but Chair Ravel was going, but you mentioned that the respondent had sought advice from the commission as part of before this contribution was made.
His treasurer had, I believe they called or write in for advice.
Called in.
He called in for advice. He asked about the contribution. Again, he didn't say that it was a candidate control committee that was making that contribution. I think for the same reasons that he had sort of the good faith belief that he was a candidate, so therefore that's why he didn't disclose that. Again, not for a nefarious purpose, but if you are misunderstanding the law initially, then your question is going to be phrased the wrong way.
Putting
Does that make
aside,
sense? I'm sorry.
yeah, just putting aside attributions of intent or reasons.
Sure.
Just are there stipulated facts, or would you would you agree to stipulated facts on that portion of the?
It is in there, and I think again, correct me if I'm wrong. The request for advice was, can this independent expenditure committee make this $100,000 contribution to another independent expenditure committee? The answer to that is yes. This is the complicating fact that had it been thrown in, I think would clearly have given the 85501 prohibition.
If I may add, the committee had been a ballot measure committee and then changed to a general purpose committee. And I think the treasurer's confusion was to make sure that that payment to the independent expenditure committee in support of this candidate was appropriate.
So that kind of concludes my initial opening. I'll turn it over to Mr. Mainardi to make his points.
Sure. Thank you, Mr. Winnick. Again, Jesse Minardi, Sutton Law Firm, on behalf of Respondent Mayor Reed, who I'd point out, I'd like to recognize, made the trip up from San Jose today, given the importance of this matter to him. So we believe that the Commission should refuse to fine Mayor Reed and respondents in this matter, and we think that it's an entirely appropriate exercise of discretion for them to come to that decision, for you to come to that decision. And I'll go over briefly, obviously we put all the details in our papers, and I'm happy to answer questions, but I'll go over briefly sort of what our arguments are, the gist of our arguments. And they basically are going back the past 3 years. So getting to the first matter in terms of this definition of candidate as opposed to an office holder, I think it is important, as Mr. Winnick did, to give a little perspective, and this is all in the stipulated facts, as to Mayor Reed's position before his controlled committee made this initial contribution, which is, Mayor Reed he's terming out in 2014. He closed his campaign committee in January 2011, so he hadn't been filing the 460s since then, since that last statement. And so, Mayor Reed, an attorney, mayor of the third largest city in California, takes a look at the statute and says, okay, well, a candidate-controlled committee is not able to make IEs or contributions to IE PACs. And so he goes through the language, which Mr. Winnick put up there, and it says, okay, well, you retain your status until that status is terminated pursuant to 84214. So he goes to 84214, and actually 84214 doesn't say anything about status. It says something about filing obligations. And so he says, well, wait a minute, now what about filing obligations? And actually 84214, the entire thing says, will terminate filing obligations pursuant to regulations adopted by the Commission, which will ensure that a candidate will have no activity which must be disclosed under the Act. And so he looks at it and says, well, I haven't had any activity to disclose under the Act for a year and a half. And so he makes the common sense determination that in light of that ambiguity, he's like, well, this is talking about filing obligations. It's not talking about whether I'm subject to this ban on political speech, essentially. And yet, Mr. Winnick and the Enforcement Division rely on Regulation 18404 to say, no, well, it's pretty clear that for purposes of this ban on political speech, that this parenthetical that's buried deep in this regulation, which again defines filing obligations, controls and defines, is a definition of who is going to be prohibited from making IEs and making these contributions. Now, the thing I'd like to actually point back in terms of talking about this regulation is a little bit earlier in this meeting, the care with which this commission went through the language of the regs that were before this commission and this definition of person versus individual and all the other decisions that the commission made at this time. And I think that it's clear that if you look at 18404, that not saying that the care wasn't taken at that time, but the effort and the result is that you don't have a regulation that is absolutely clear with respect to whether somebody is a candidate or an office holder. Because you look at the plain language and it says, well, a candidate is obligated to file campaign statements under the Act until his or her status as a candidate is terminated. And, and a couple things happen after that. It said, well, does it ever say how your status specifically, as your status as a candidate is terminated? It doesn't. And then, it says, well, a candidate is really the broader term, includes office holder, and yet later it goes on to talk about office holder filing requirements. And then it talks about candidate or office holder filing requirements. So, I mean, I think the point is just that the reg is, I would just say, inartfully drafted. And I think that the intention of the reg, because it is all about filing requirements, the intention of the reg is really, we want to make sure that if people are raising and spending money, that they know that they have to disclose it. And I think that's, again, I mean, I think that's what the intent was. I don't think the intent was to define whether somebody is subject to this prohibition on political speech. And I think the Liu opinion from 1987, when there were no limits on independent expenditures or contributions, similarly, it was about filing requirements. And it's also, quite frankly, similarly sort of difficult to read and to follow, particularly because it deals with filing requirements that haven't existed for 20 years. And so I think the point that we're just making is that in this context of vagueness and ambiguity, what is the import? And the import is that in the constitutional context, when you are banning political speech, when you're saying you cannot spend money that is not directly to the candidate, and the one thing I would correct Mr. Winnick is that none of this money went directly to the candidate. These were not contributions. These were this was a contribution to an independent committee that made independent expenditures. And so when you're talking about that, quite frankly, the constitutional requirement for interpreting those rules in vagueness is that you have to err on the side of the speaker. And I think what that means is that, you know, based on these constitutional requirements, you can't justify basically imposing or bringing an enforcement action when it is so vague. And we didn't quote in our papers, but I would just mention it here in the Wisconsin Right to Life case, which was, I believe, 2009, maybe 2008, dealt with a similar issue at the federal level. And there they had a ban on corporate electioneering communications. And there was this issue as to, well, you know, what is electioneering communication? Is it the same thing as express advocacy? And it was unclear under the definition. And the Supreme Court was very clear. And they said when it comes to defining speech, which is subject to the ban, there it was, you know, the federal ban, but we could apply it here, a ban, political speech, we give the benefit of doubt to speech and not censorship. And so, you know, we believe that our position is certainly reasonable, and that if you look at this reg, it's far from clear, and that the reg is thus not sufficient under constitutional requirements to impose a fine under the facts of this case.
Can I ask you a quick question? You talk about the receipt of the funds to a separate committee. Yes. Is in the law that, or the ordinances, or in San Jose, are there any limitations for contributions to those types of?
Actually, there had been limitations on contributions to independent expenditure committees, but they were challenged, and it went through. It was sort of a complicated procedural process, but ultimately were found to be not enforceable under the Constitution.
Yeah, and I'd ask you from a legal standpoint, both of you, in terms of the legislative intent of Prop 34, was it, because it was consistent when they enacted campaign contribution limitations, is there a connection between those two things in the way that you would interpret the law, or not?
Well, I'll go first. We took a look at, you know, it was a ballot measure, and we took a look at the you know, the legislative intent, and quite frankly, we couldn't find anything with respect to this issue. And in terms of the intent for this particular 85501. But you know, the rationale that has been offered up by the legal division, I think we talk about in our papers, which is that it sought to prohibit circumvention.
Right.
Circumvention of the contribution limits, and you know, we talk about that a little bit because if you drill down on it, it doesn't in our opinion, doesn't really make sense, because again, when we're talking about independent expenditures, and you know, we're talking about things that the Supreme Court has defined as a matter of law, as not being corrupting. And you can't. Well, let me back up and say it's unclear if we're talking about the corrupting influence on the candidate or the person who controls the measure, or who is spending.
Right.
Right. And
that was actually my question.
Okay.
I mean, I'm wondering whether that provision related to the money that would somehow circumvent to be given to in this case, Mayor Reed, as opposed to the ultimate recipient.
Right, right. And I think what we would say to that is that if that truly was the intent, that it's still not constitutional, because then what you can do is you can basically still limit the amount of contributions that are received by that controlled committee. And but what the statute said is you're actually limiting the expenditures. So under it's overbroad, essentially. It's completely overbroad. So
sorry for the interruption.
Yeah, no, please. That was great.
I had a question about the interpretation of the language you've both presented. I mean, I'm convinced, actually, I think Mr. Winnick convinced me that what we have here is a somewhat complicated scheme of interlocking provisions. The part I'm having trouble with is seeing the vagueness or the ambiguity in what could be a simpler, could certainly be a simpler interplay, but Section 82007, which is the definition of candidate, says that you retain that status until such time as that status is terminated under 84214, right?
Right.
Okay, so then in terms of defining candidate and for how long you remain the candidate, the statute seems pretty clear to me that now we're looking to 84214 to figure out whether your status as a candidate still applies. So far, so good?
Well, the only thing I would say is that 84214 does explicitly talk about filing obligations, and it doesn't talk about a status as a candidate.
Right, but 82007 tells you that you look to 84214 in order to determine whether your status as a candidate still exists or persists.
Well, I would say that that's a reasonable inference, but I would
that's
say
the ambiguity that you see in there?
That's one of the ambiguities, yes. I would say that's a reasonable inference, but I think that when you're talking about constitutional requirements in terms of interpreting, I think you can also look at the reasonable inference, which is, wow, well, it's not in 84214. So if I look at in terms of my status as a candidate, if I look at 84214, it talks about filing obligations, and it talks about making sure that there's no activity that I have to disclose. And wow, I haven't filed these 460s for a year and a half. And so why would I still be a candidate? I'm not running again. I'm terming out, and I don't have a campaign committee. And I think, again, I think that's a reasonable inference as well. And I think that when we have these two reasonable inferences, what we're required to do is interpret that statute in a way under the First Amendment when we're talking about a ban on political speech.
I mean, if you go and you read 82007 and you try to figure out, okay, when do I stop being a candidate, and it tells you the place to look to see whether that status is terminated is 84214, and then you look at 84214 and you see the entirety of the language there, as you say, relates to filing obligations, and it says look to the regs on the filing obligations. I don't see how you conclude anything other than that's the definition of when my candidacy terminates. I mean, otherwise you have to go back to 82007 and say that there's some problem in the language because this provision about terminating your candidacy status pursuant to 84214 is a mistake or an errant citation or something, which I think we're supposed to presume didn't happen. So if we get over that hump for a moment and we go from 82007 to 84214 and we kind of read that to say you have to look to 84214 to determine whether your candidacy is terminated, is there some other ambiguity that you're or vagueness that you're trying to point us to in terms of the application from Regulation 18404D in terms of what that has to say about when candidacy is terminated?
Well, 18404D, yeah. Well, yeah. In 18404, we think that there's the similar issues in terms of vagueness, which is that you have first of all, basically a candidate and then a parenthetical, which terms includes an office holder. So, I think it's reasonable to start second guessing at that point whether a regulation which is about filing requirements is really going to be applicable to this ban on political speech. But secondly, if you keep going, it says, well, look, a candidate which term includes an office holder is obligated to file statements. So now we think, okay, a candidate, if you follow this logic, a candidate is sort of the bigger circle, an office holder is within that. But then, if that's the case, then why do you continue to go on and use the term office holder? It doesn't. Why is the next sentence begin, an office holder might file campaign statements? And then why, when it continues onwards and it talks about when they have control committees, when they don't have control committees, why do you say candidates or office holders? And again, I think what probably it was probably about ensuring that folks report all of their raising and spending money, which, by the way, the control committee did report all of its activity because it's its own committee, right, with its own filing obligations.
So there's no dispute that at the relevant time, May Reed was a candidate or office holder with one or more control committees, right?
Actually,
is that a stipulated fact? That's disputed.
It's stipulated that he was an office holder. That's correct. What we're saying is that there's
office holder with one or more.
That he had a control committee. That's correct. Yeah.
Okay.
That's correct. That's correct. But we think that, again, if you're looking at this and you have this apparently definitional statement within parentheticals for a reporting reg that then goes on to actually reference office holder and or candidate, that it certainly gives rise to an ambiguity. And given that ambiguity, and given the fact, again, we're talking, this reg is about reporting, but what we're talking about here is a ban on political speech. You have to interpret it in favor of the speaker. So I would just to move on, because I think I want to give opportunity, obviously, for back and forth. In terms of the other constitutional aspect, which I alluded to and Mr. Winnick alluded to too, is, we do think that this statute, 85501, in and of itself is unconstitutional, and we think that Citizens United and the Long Beach case, SpeechNow.org, the Thalheimer case make it pretty clear that essentially all those cases have established that independent expenditures in and of themselves cannot give rise to corruption or the appearance of corruption. And that justification is really the only constitutionally acceptable justification for limiting political speech. The Supreme Court hasn't recognized any other justification. And the justification that was offered here is the one that we spoke with the chair earlier, which is, well, what about a controlled committee? And isn't that getting around contribution limits? And the issue here is that, well, if that's the intent, the statute as it's written is completely overbroad, constitutionally overbroad. Because if you really want to enforce contribution limits, what you do is you say, if you have a controlled committee, then that controlled committee, if it's doing ballot measure stuff, doing IEs, whatever it is, that committee is subject to any applicable contribution limits as well. So, in other words, if I give to Mayor Reed, it's $500, then I can't give to his other ballot measure committee because I've already given $500, and $500 is the limit. But what the statute does here is it says, no, you can't speak at all if you're a candidate control committee, one way or the other. And in the papers, the Enforcement Division does make a little bit of this distinction in Citizens United about corporate speech versus other speech, and actually says, well, the the Supreme Court hasn't talked about candidate-controlled committees, which, if there's any speech that's supposed to be protected, it's supposed to be the speech of candidates and office holders in terms of making their statements. And in Citizens United, they say, we find no basis for the proposition that in the context of political speech, the government may impose restrictions on certain disfavored speakers. And so, to say that we would do it for candidates as opposed to anybody else, it just doesn't conform with applicable case law.
Do we have even the authority to hold the statute unconstitutional?
So, yeah, great question, and that's what Mr. Winnick was talking about earlier. There is a provision of the California Constitution, Article 3, Section 3.5, which talks about an administrative agency and says it may not refuse to enforce in the absence of an appellate court decision, basically declaring a statute unconstitutional. But what the case law, both Ninth Circuit and California case law, make clear is that you don't have to have a ruling with respect to that particular statute. And that's what the two cases that we cited. And, the standard is, the standard to, I can read what the standard is, but, is it so patent or clearly established that no reasonable official can believe the statute is constitutional? I call it the sort of the plain language standard, I would say, is there any way to defend this in court? And I think that's a question you can ask your general counsel in closed session. And I think the answer is going to be no. And I think that if that's the answer that you get, I think it becomes patent and clear, and you have the ability to not enforce. Now,
read that standard again for me, please.
Sure. This is from the Lockyer case, which is back in 2004. They say, is it so patent or clearly established that no reasonable official could believe that a statute is constitutional? And now I'll give you an example of
patent or clearly established.
Yeah, that's right. That's right. And in the two cases we cite, one was a pledge that you weren't a member of the Communist Party, and that particular statute hadn't been deemed unconstitutional. But they said, look, this is never going to stand up. The other one was a little more complicated, but it had to do with obscenity laws, and there had been regulations that were similar, but not the same as the regulations at issue. And basically the court said, no, you know what, given this prior, these other holdings, that, it was obvious, basically, that they weren't going to be able to enforce these particular regs. So, I think if you take that together, you take, the Constitution plays into both aspects here, and, the Commission has the ability, to rule with respect to, to decide not to enforce based on either of those arguments. But I think if you wrap that up also in terms of the inadvertent, and I do think it was inadvertent mishandling of this case in the very beginning. I don't ascribe any sort of malintent to Mr. Winnick. I think it was just a plain mistake. But yet there was a mistake made at the very beginning of this case in how it was handled, which was that there was correspondence back and forth between our client, our firm in particular, and the Enforcement Division that ultimately was released to the press, to the complainant and to the press. And quite frankly, our client feels that he was damaged by that, and that his message was compromised by that breach of policy. And so, if you take all of these reasons together, we think that certainly that the Commission has the discretion not to issue a fine in this case. And I just close by saying that Mayor Reed, he's here today. He's very sincere in his conviction that he did not do anything wrong, and that the issue is not really money. If we were arguing about the amount of the fine, that's something that Mr. Winnick does all the time. It's not $100 versus $4,000. It's whether he broke the law, and our client is very convinced that he didn't, and he's willing to fight, all the way up to the Supreme Court if he has to. But essentially his argument is that, look, if you look at the plain language, at best this is ambiguous. And if you're listening to the dictates of the Constitution, it has to be enforced, or it has to be interpreted in his favor. But in any way, it's clearly an unconstitutional statute. So for that reason, we respectfully request that the Commission decline to impose a penalty in this instance.
Thank you, Mr. Minardi. Does anyone have any questions for Mr. Minardi, or do you want to wait until we hear? Okay. Mr. Winnick.
Thank you again. I just want to address a few of the points that were made. The vagueness issue in particular, I brought with me the actual Commission report for the reg. I wanted to share it with everyone since we mentioned the vagueness issue. Yeah, sure. The staff report itself, I'll wait just 1 second until you have it.
Thank you.
The staff report itself on page 2, full paragraph 3, starting with new subdivision D, talks very specifically about the termination of a status of a candidate. So even from the very beginning, the staff report contemplated 18404 having status as a candidate. And I'm really not saying this to be flip, but Mr. Minardi works for Jim Sutton's law firm. They actually were notified. If you see, we attached the full public record. They actually received a copy of that at the time it was being implemented. So they've been on notice for the better part of 14 years that that's the status of a candidate. Plus, you know, we've talked about advice letters, and you know, Mr. Minardi has discounted them in some ways in his briefing, but they are relevant to help you tie together these loose issues. And there's been a lot, over 62 opportunities to have a look at advice letters to see that that connection has been made. So I appreciate his point about the imperfections of language, but I do think that the vagueness issue is being overstated. There's been lots of opportunities, particularly for these sophisticated parties, to understand what all this means. The last point made on vagueness dealt with candidate versus office holder, and I think the key point he's missing is that every office holder is a candidate, but not every candidate is an office holder. So if you read 18404, they use the office holder when referring to people specifically, but they're not mutually exclusive. One is a subset of the other. For the constitutional issues, just to briefly restate my point, the state constitution is fairly clear about what needs to happen before the commission can overturn one. There has not been an appellate court determination on the statute. Mr. Minardi referenced the Lockyer case, but the Lockyer case was a lot more limited. We covered the details of that in our brief, so I won't repeat myself too much, but we gave a much more fuller explanation of Lockyer and why that particular regulation that had some precursors to other regulations that were found invalid was a much closer tie to having a specific statute or regulation declared unconstitutional than the case at hand here. Next issue talked about sort of the degree of harm with regard to our mistake, and he's correct. We released a specific letter that should not have been released. However, I think he's overstating the public harm a little bit for this reason. If you recall, there were two parts to the transaction. There was the making of the contribution and the receipt. All of this was reported from the complaint all the way through the resolution in the local media quite extensively. So when the contribution, when the recipient committee stopped using those funds, that was reported in the paper. Again, the letter should have been released, and that's a mistake on enforcement that we accept, but I think the public harm, again, is being a little bit overstated because of the circumstances of this case, a lot of that was reported without reference to the letter. And then just lastly, you know, Mr. Minardi's been asking you to view this through the lens of the First Amendment. But again, it really is for a court to determine what violates the First Amendment, not necessarily for the commission to invalidate a statute based on a legal determination that violates the First Amendment. I think it goes back to the same issue that's alluded to in the Constitution, which is, you know, it's not necessarily the role of the commission to decide whether something is constitutional or unconstitutional or violates First Amendment or doesn't violate First Amendment. So just to sum up very quickly, you know, given the full range of tools available from our advice line, our advice letters, the opinion, the statute, the regulation. Commissioner Eskovitz makes a good point. The Act always has its complexities. But this particular section was something that is very common in terms of the activity. The prohibition, from our perspective, is very well known, which is why there are so many advice letters on it. It's certainly something that a sophisticated party should have had knowledge of or could have asked about. And again, not ascribing specific intent to violate the Act, but certainly it was a violation of the Act, I think, pretty clearly under our statute and regulations. The public harm that we've articulated we think was serious. There was money spent that other people did not have the ability to do. Prop 34 gave the public purpose of limiting what candidates, how much their contributions could be, and that is an important public purpose, and it was passed by the people of the state of California. So it was our job to enforce it, and that's what we did. We're asking you to find that the Act was violated, Section 85501, and impose an appropriate penalty.
May I just comment on this?
Yes,
very
please.
quickly? I just want to say I appreciate Mr. Winnick pointing this out, but the one thing, and we mentioned this in our brief, is that the regulatory history when you're talking about a prohibition on speech is not particularly relevant, because what the Constitution requires is somebody should be able to read the regulations and the statutes themselves and determine their obligations based on those. And we quote Citizens United, where they say that you shouldn't have to go hire a campaign lawyer like me to figure out what your obligations are before you actually speak. So, and you shouldn't have to look at advice letters, etc. We should look at the plain language of the reg, which we would submit as at best ambiguous and vague.
Thank you. Are there questions by any of the commissioners, or should we retire to discuss the matter? Okay.
The last thing
Yes,
I'd just like to say
please.
is thank you to both Mr. Winnick and Ms. Brereton for the logistics of this. It was a lot of back and forth, but I think we
Appreciate
made
it.
work.
Thank you both. That was very well presented.
Yes.
I appreciate it.
Okay. We will adjourn to closed session or retire to closed session and come back with our decision.
Good job.
Thank you. We are returned from closed session. After deliberation, the Commission has voted to find that respondents have violated Section 85501. The Commission also finds that in this case, the Commission declines, due to the provision of the California Constitution, to find this section unenforceable. The Commission has also found that due to mitigating factors pursuant to Regulation 18361.5, that this matter warrants a fine in the amount of $1. Pursuant to the Administrative Procedures Act, the Commission will issue a formal written decision within 100 days of today. The Commission has delegated to the Chair the authority to execute the written decision in the name of the Commission. The decision of the Commission shall not be effective until the written decision is executed and served on all parties. Thank you. Oh, yes. Is there a motion to adjourn the meeting?
I'll move that we adjourn.
Second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Ravel.
I am not going to adjourn the meeting until I say that this might be my last meeting of the Commission. Not of the Commission in closed session, but the public meeting of the Commission, that the staff and people who are appearing before the Commission and the community that's interested in these issues are amazing, simply amazing. And I, have the highest respect for everybody